to do a roll call. Pam, you're muted if you're speaking.
Oh, sorry. Yeah, I just was counting to make sure we had a quorum, but we do. So I will begin the roll call. Commissioner Brankard, are you present? Good morning. Commissioner Candelaria?
Present.
Commissioner Dominguez?
Present.
Commissioner Frey?
Fry, yes, I'm present.
Fry. Okay, thank you for correcting me. It's Fry.
Sure.
Commissioner McWilliams?
Present.
Commissioner Modi? Commissioner Pertain? Commissioner Rader? Vice Chair Cipher? Commissioner Thompson?
I'm here.
Commissioner Velasquez?
Present.
Commissioner Vigil? Commissioner Zemlick?
Present.
Good morning. Chair Stringer?
Present.
Thank you. You do have a quorum, Madam Chair.
Thank you all very much. Next on the agenda is the approval of our agenda for today. Any comments or questions? Commissioner Dominguez, please.
Madam Chair, before we move to a motion, just a quick question to make sure that everything's covered. In looking at item number 7, which is WQCC 22-21, there was also a pending motion from Environment Department. That was a motion to toll upcoming deadlines. Does that need to be included as an agenda item, or will that be addressed through either of the other motions?
That's a good question. I'm going to ask for Council Sanchez to weigh in on that to make sure we do this correctly. I would think it would be another agenda item, but I guess it could also be wrapped up into one of these two. Council Sanchez? Is he here?
Madam Chair, I think Council Sanchez, unless he's calling in, is out of town.
Oh, okay. Well then, given that, this is another question about this matter doesn't have a hearing officer assigned, and so there's the question of whether or not we assign the hearing officer, and he makes the decisions on these matters. So I was hoping Council Sanchez would be able to help us walk through that. So in light of that, I say let's see, let me think about this, or if any commissioners have any further discussion on their opinions. Commissioner Brankard.
Well, agenda item 7A refers to the petition for review, so I would think that all matters that are currently pending under the petition for review would be before the commission at this point, whether it's appointing a hearing officer or any immediate motions that need to be dealt with.
Okay. Yeah, that is very logical to me as well.
Is there anybody else here from the AG's office, though?
Doesn't look like it.
That's a very good question. Usually if commission counsel is going to be on extended leave, the AG's office would provide a substitute counsel during that time period.
All right, I am also myself just returning from 2 weeks leave, so I didn't realize Council Sanchez was not going to be here. Well,
Madam Chair, if it also helps regarding the hearing officer side of it, whenever there has not been a hearing officer assigned to a particular case, the chair serves as the hearing officer up until the point in time that a hearing officer is assigned.
yes, thank you for that, Commissioner Dominguez, which leads me to understand that we as a commission and me as the chair could consider these matters, some of these matters, like the tolling question, prior to appointing the hearing officer. I don't know if there's any discussion or preference from the commissioners. I did plan to bring that up during that agenda item to discuss. So we're focused on the agenda right now. So I think given that we're going to wrap up the tolling item into the request for review of the petition, we can address those matters in more depth when we get to that agenda item to figure out if we're going to assign a hearing officer or make decisions as a commission.
Thank you, Madam Chair.
Thank you, Commissioner Dominguez. Any other comments on the agenda items? Or a motion to approve the agenda?
So moved.
A second.
Thank you, Pam. Commissioner Brankard moved to approve the agenda and Commissioner Vice Chair Cipher seconded. Can we have a roll call vote, please?
Yes, ma'am. Starting with Commissioner Brankard, how do you vote?
Yes.
Commissioner Candelaria,
Yes.
Commissioner Dominguez,
Yes.
Commissioner Fry,
Yes.
Commissioner McWilliams,
Yes.
Vice Chair Cipher,
Yes.
Commissioner Thompson,
Yes.
Commissioner Velasquez,
Yes.
Commissioner Zemlick,
Yes.
Commissioner Modi, have you joined us? Commissioner Pertain, have you joined us? Commissioner Vigil, have you joined us? Chair Stringer, did I take your vote?
Not yet, but I will vote yes.
Vote yes. The motion to approve the agenda passes.
Thank you. Next up is approving the July 12th minutes that were included in our commission packets. Any discussion, proposed changes, or motion to approve?
Madam Chair,
Yes,
Commissioner
Commissioner.
Dominguez, I would make a motion to approve the minutes as presented.
Second.
Thank you both. Shall we have a roll call vote, please?
Commissioner Brankard, your vote?
Yes.
Commissioner Candelaria,
Yes.
Commissioner Dominguez,
Yes.
Commissioner Fry,
Abstain.
Commissioner McWilliams,
Yes.
Vice Chair Cipher,
Yes.
Commissioner Thompson, Commissioner Velasquez,
Yes.
Commissioner Zemlick,
Yes.
Chair Stringer.
Yes.
Madam Chair, the motion passes.
Thank you. Next, we want to introduce two new commissioners who have joined us. We want to welcome Katie Zemlick and Bonnie Fry. If I could ask each of you to just give a few brief sentences about yourself so that we have an understanding of your background. And Commissioner Zemlick, if I'll ask you to go first, please.
Sure.
Thank you, everyone, for welcoming me. My name is Katie Zemlick. I am the Bureau Chief of the Hydrology Bureau at the Office of the State Engineer. I have a PhD in engineering from UNM and a master's in water resources from UNM. And I've worked in water in New Mexico for probably the last 12 to 15 years. And I've been with this agency for 3 years.
Thank you so much. Welcome. We look forward to working with you. And next, Commissioner Fry. Thank you for letting us know how to pronounce your name. I think I might have mispronounced it if I were the one to go first, Pam. But Commissioner Fry, please introduce yourself.
Hi, good morning. Yes, I'm at the New Mexico Bureau of Geology and Mineral Resources here in Socorro. I'm a geochemist and have a geochemistry degree from New Mexico Tech and a geology degree from University of South Florida. And I run a laboratory here at the Bureau for water quality mainly, but we serve New Mexico Tech, working with students on just about anything that's
Thank you. Your microphone faded out just a little bit there at the end. I'm hoping that's not a technical issue on my end. People, can you still hear me? Okay. All right. Thank you, Commissioner Fry. Welcome to the commission, and we look forward to working with you as well. Moving on to our next agenda item is an opportunity for the public to comment. Are there any members of the public who would like to provide public comment? And Pam, I'm assuming you haven't had anyone identify themselves?
No, I haven't.
Okay, well, I don't see anyone chiming in or any hands raised, so I'll take that to mean no public comment today. Next, moving on to item number, oh, sorry, there is someone.
Good morning.
Ms. Sher,
I'd like to make a public comment, please.
please proceed.
Hi, good morning to the members of the New Mexico Water Quality Control Commission. My name is Catherine Shearer, and I'm a resident of Santa Fe. Thanks for the opportunity to address you today. My comments today concern the groundwater discharge permit DP1132 for the radioactive liquid waste treatment facility operated by Los Alamos National Laboratory. The NMED Secretary has not fulfilled his responsibilities to complete the administrative record for DP1132. He has not taken action to inform the public of his reasoning for issuing the permit. He was required to recognize that the facility manages hazardous waste and so must be regulated under the Hazardous Waste Act rather than the Water Quality Act. He has not responded to the significant public comments received on the record. Thus, the administrative record in this matter remains incomplete. I support the request by CCNS and hope that, first, the Commission remand this matter to the Secretary for completion of the administrative record, and second, that the Secretary determine that the radioactive liquid waste treatment facility is in fact a hazardous waste facility and must be regulated by the New Mexico Hazardous Waste Act. Thank you very much.
Thank you, Ms. Shearer. Any other public comments? Okay. Double checked, went through the list. I don't see any additional hands raised. Okay, so now we'll move on to agenda item number 6, WQCC case 22-01, the matter of the Canon Air Force Base's permit for permit review of discharge permit renewal and modification for DP 873. And Gregory Chakalian is the hearing officer on this matter. So I will turn it over to you, Mr. Chakalian.
Chair Stringer. Good morning, commissioners, members of the public, and the parties. We will hear oral argument in WQCC 22-01. This is the Canon Air Force Base petition for a permit review of a discharge permit renewal and modification. That permit number that was issued in December of 2021 by the Bureau is DP 873. The petition was timely filed January 13, 2022. There was a motion to remand back to the Bureau filed by Canon Air Force Base January 28 of 2022. I was appointed as the hearing officer under the duties and obligations of 20.1.3 NMAC. On March 16, 2022, the motion to remand had not been dealt with by the commission at that point. It's not a dispositive motion, so the parties agreed to have me rule on it. I did. It was denied as untimely made. There was a waiver of the 90-day deadline. It was approved by order of the commission on March 28, 2022. I issued a scheduling order in this matter on the same day, setting out the briefing schedule and the rules in control of today's oral argument. I specifically say oral argument for the new members of the commission because the record is closed in this matter. Under 20.1.3.16 NMAC, no new evidence shall be admitted. This is important because there was a motion to supplement the administrative record to include 6 documents that were not part of the administrative record that was timely filed in the Office of Public Facilitation by the Bureau. Of these 6 documents, 2 were unopposed and were admitted by stipulation. The other 4, there was a full briefing schedule on it, and I allowed 3 of the 4 documents to come in to supplement the administrative record. That was done at the end of June or the first day of July. So the evidence that the parties will be arguing over is included in the administrative record as supplemented by my order. Each party has 45 minutes today. There are 2 parties. The petitioner will go first. Any party can reserve time for rebuttal. And importantly, the commissioners are encouraged to ask questions of the parties during oral argument. This does not add time to any party's 45 minutes that has been already agreed upon. And with that, I've also encouraged the parties to use demonstrative exhibits that may help in their discussion this morning. Those demonstrative exhibits are not part of the evidence. Are there any preliminary matters before we begin from the parties? Hearing none, petitioner, you have the floor.
I'm going to share my screen.
And Pam, would you time this once the screen comes on?
Yes, I will.
Thank you.
Okay. Thank you, Mr. Hearing Officer. Good morning, Commissioners. I am Captain Jordan Davis, and I'm here with Major Anthony Threats. And we are representing Canon Air Force Base in today's permit review hearing on DP 873. Before we move forward, Canon Air Force Base would like to request 5 minutes be reserved for rebuttal. Canon Air Force Base is here before the Water Quality Control Commission today to request that the Water Quality Control Commission reverse InMed's decision to issue DP 873, or in the alternative, request that the Water Quality Control Commission modify the permit. There are three main reasons why the WQCC should reverse or modify DP 873. First, DP 873 overlaps with the Air Force's Comprehensive Environmental Response, Compensation, and Liability Act, or CERCLA response, in contravention of CERCLA 121E. Second, DP 873 contains conditions that are subject to set aside because they are arbitrary and capricious and contrary to law. Third, there is no waiver of sovereign immunity that makes DP 873 enforceable against the Air Force. Before we get into the argument, I wanted to take a minute to familiarize you all with the site that we're discussing in today's proceeding. So as you can see, if you can follow my cursor, the black dotted line here is the boundary of Canon Air Force Base. The orange box that you see here is the wastewater treatment plant, and this is the subject of DP 873. So water from the wastewater treatment plant is sent to the North Playa Lake, and it is also sent across the base here to this holding pond labeled Pond 1 on the map. Pond 1 is located on the Whispering Winds Golf Course, and water from Pond 1 is used to irrigate the golf course, as well as the softball fields, the dog park, and the driving range. And that's done through an irrigation and sprinkler system. I'll also point out here the red box. This is the former lagoon. So in a previous time, it's not currently used this way, but sewage was stored in this area. Now sewage is stored in these lined basins that you see here. And the former sewage lagoon is a part of our CERCLA response, so I just wanted to point that out, although it is not an area where water from the wastewater treatment plant is currently discharged. So DP 873, the most current version, was issued to Canon Air Force Base on December 15th, 2021. And during the draft comment period on the draft permit, which was issued in February 2021, Canon pointed out to InMed that there were significant legal issues with this permit. And Canon's comments really focused on the fact that many of the conditions in DP 873 for the first time pertain to regulation of PFAS, or perfluoroalkyl substances. Additionally, Canon pointed out that many of the conditions in DP 873 seem to be trying to regulate past discharges, when the reason for this permit should be to regulate current discharges coming from the wastewater treatment plant. New Mexico responded to Canon Air Force Base's comments by stating that the main objective of the discharge permit is to monitor current discharge at Canon. The purpose is not to require remediation of existing contamination as a result of previous discharges. However, as we'll discuss in more detail, many of the conditions in the permit do target past discharges. For example, Condition 49 of the permit requires a soil investigation work plan that targets areas that are not current discharge areas. So that conditions like that are targeted at past discharges. And this is a problem because the Air Force is addressing past discharges of perfluoroalkyl substances, or PFAS, through its CERCLA response on Canon Air Force Base, which is already underway. CERCLA authorizes the President to respond to threatened releases of pollutants or contaminants that may present an imminent or substantial threat to the public health or welfare. And under Executive Order 12,580, the President further delegated lead agency authority for CERCLA responses to the Air Force when the contamination arises from an Air Force installation. So on Canon, the Air Force is the lead agency to carry out this CERCLA response. I want to pause here to give a quick introduction to PFAS for those who may not be familiar. So PFAS, or polyfluoroalkyl substances, are a class of synthetic compounds that possess a chemical structure that gives them unique properties, including thermal stability, the ability to repel water and oil. And these chemical properties make PFAS very useful in a lot of day-to-day objects that we use. So for example, PFAS are found in food packaging, they are found in waterproof clothing, cookware, things that we use every day in our lives, paints. They're also found in firefighting foams, such as aqueous film forming foam. And on military installations like Canon, AFFF, or aqueous film forming foam, was used to fight fires when there were things like aircraft mishaps. Currently, the Air Force really restricts the use of AFFF because of the health concerns associated with it.
So the Air Force is taking affirmative steps to reduce use of AFFF, and it's only allowed in emergency situations. So back to the CERCLA response. The Air Force is addressing this contamination through CERCLA, which is a multi-phase process. The first phase of the process was the preliminary assessment site inspection, which was completed in August 2018. The current phase that we're in is the remedial investigation. And at the same time, the Air Force is going above what's required, and they're conducting a pilot study on the southeast corner of Canon that is being done in an effort to speed up treatment of PFAS impacted water on the base. So I'm going to take a moment to go through each of the phases and explain what the objectives were. And it's important for me to do this because it lays the foundation for me to explain how DP873 overlaps with what we're already doing under CERCLA. And then we'll be able to more fully explain why that's an issue. So phase one was the site inspection. The specific objectives of the site inspection were to determine the presence of PFAS in soil, sediment, groundwater, and surface water at PFAS release areas. And the ultimate goal was to identify potential receptor pathways that could have an immediate impact on human health. And this objective was carried out by sampling soil, subsurface soil, and groundwater, as well as sampling monitoring wells, sediment, and surface water. There were a total of 122 samples collected during the site inspection, and those samples were analyzed for 16 PFAS compounds, including the PFAS compounds that New Mexico regulates. Additionally, there was an expanded site inspection, and the purpose of this was to evaluate the migration of PFAS off base. And it's important to note that if the Air Force found a drinking water supply that had concentrations of PFAS, PFOA to PFAS constituents above the EPA lifetime health advisory of 70 parts per trillion, that drinking water source was cut off, and those individuals were provided an alternative drinking water source by the Air Force. So this is important to note because it shows that the Air Force is taking affirmative steps to make sure that human health is not endangered by PFAS, which is a similar goal that the New Mexico Water Quality Bureau has by implementing DP873. So the next phase, the phase that we're currently in, is the remedial investigation, and this started in 2020. And the purpose of the remedial investigation is to even build more upon what was done during the site inspection to really fully identify the nature and extent of PFAS in the vicinity of Canon Air Force Base. And this is going to be accomplished through installing 26 groundwater monitoring wells, sampling of these new wells, and also sampling of existing groundwater monitoring wells, surface and subsurface soil sampling, surface water and sediment sampling, and we're also going to install 12 lysimeters. So for those who are unfamiliar with lysimeters, they are used to evaluate the leaching of chemicals from soil to groundwater. And when they're used successfully, they can be one of the best ways to determine the leachability of compounds into groundwater. So this is really going to help us understand the extent of PFAS in the groundwater around Canon. All the samples that are taken under the remedial investigation will be analyzed for PFAS, and a report will be generated in general accordance with EPA's guidance. So importantly, the remedial investigation focuses on the same areas that are being focused on in DP873, and I've highlighted in red here the areas that overlap. So the remedial investigation is looking at the North Playa Lake, the golf course, and the areas where we've used wastewater, reclaimed wastewater to irrigate the dog park, the softball fields, and the driving range. And the remedial investigation is also going to take a look at the former sewage lagoons. And many of this work is already underway. But these are the areas that overlap with DP873. In addition, there are some other areas like fire training areas and hangars that will be investigated as well. And just to go back over where that's at on the map, the North Playa Lake is here, the former sewage lagoons are here, and then we have the golf course, the softball fields, the dog park, and the driving range where we've used water in the past. So as you can see, just from a brief overview of the remedial investigation, there are a lot of overlap between the areas that DP873 focuses on with what we've done under our CERCLA response. And this is a problem, not just from a practical perspective, but also from a legal perspective. It's a problem from a practical perspective, because if we have multiple layers of regulation trying to achieve the same goals, we're necessarily going to be slowed down because we're looking to different sources for approval of the same activities. Additionally, CERCLA 121E states that no federal, state, or local permit shall be required for the portion of any removal or remedial action conducted entirely on site, where such remedial action is selected and carried out in compliance with this section. So importantly, 40 CFR Part 300 defines on-site as the areal extent of contamination and all suitable areas in very close proximity to the contamination necessary for the implementation of the response. So what this means is that in areas where the Air Force is already completing these CERCLA actions, such as the former sewage lagoons, the golf course, the softball fields, the dog park, and the driving range, there should be no state permitting requirements for those areas. And case law supports this notion. So Town of Acton v. W.R. Grayson Co. states that allowing local governments to impose disparate requirements on responsible parties would thwart or at least pose a significant obstacle to the accomplishment of CERCLA's objectives. Another case, the Rhode Island Resource Recovery Corporation versus Rhode Island Department of Environmental Management, states that the ban on permit requirements is part of a congressional effort to streamline these remediations at hazardous waste sites and effect prompt cleanup of those sites. So now I'm going to take some time to go through the conditions that overlap between DP 873 and the CERCLA response. This is really going to show you exactly which conditions we would be asking that you modify if you choose not to reverse the entire permit. And I'm not going to read all of this verbatim because it is a lot of text, but I just want to highlight here that on the left side, we have the permit condition that's found in DP 873. This is an explanation of how this condition conflicts with our CERCLA response. And then I've provided a citation to the administrative record where you can go and look at this information in more detail if you're interested. So conditions 25 and 26 of the permit pertain to the installation of new groundwater monitoring wells. And under the Remedial Investigation Work Plan, the Air Force has proposed to install 26 new groundwater monitoring wells. And 3 of those wells are going to be installed in the area where we've used reclaimed wastewater for irrigation purposes. And this action is already underway. 2 of those 3 have already been installed. So this should satisfy the requirement of condition 26 to install 4 new monitoring wells under DP 873 in the down gradient direction. Additionally, condition 27 requires Canon to use those new monitoring wells to sample for certain constituents, including 3 PFAS constituents. And the RIWP includes groundwater sampling for PFAS constituents as well. So that's also already being addressed under the remedial investigation. Condition 28 requires a professional survey of all the wells, and surveying of the wells would also occur under the CERCLA response. That's discussed on administrative record number 5411. And then condition 30 would require Canon to do semi-annual groundwater sampling. The remedial investigation work plan also calls for semi-annual groundwater sampling for PFAS constituents. There's a direct overlap there. And then moving on to condition 49, which I touched on in the beginning of the presentation. Condition 49 requires Canon to submit a soil investigation work plan. And the soil investigation work plan is supposed to address the reuse areas where we've used reclaimed wastewater, the former sewage lagoons, the wastewater treatment plant, and the North Playa Lake. However, the remedial investigation work plan also includes a soil investigation work plan that is currently underway. And as part of that work plan, we have proposed 153 soil samples. And this RIWP work plan also covers the former sewage lagoons, the reuse areas, and the North Playa Lake. And I also want to highlight this condition because if you remember back to the beginning of the presentation, I showed New Mexico's stated intent for this permit, which is to regulate current discharges from the wastewater treatment plant. However, condition 49, as you can see here, would require Canon to do a soil investigation at the former sewage lagoons and the wastewater treatment plant. These are not areas where wastewater is currently discharged. These are areas of past discharges. So by requiring Canon to do a soil investigation at areas that are not areas of current discharge, New Mexico is contradicting its statement that this permit only targets current discharges. Condition 49 would also require corrective action if samples from these areas exceeded a certain level. And so this is trying to require Canon to complete potential remediation projects for past discharges when those are more properly dealt with under CERCLA. So just to give you a little bit of information about the plan for soil sampling, I'll go quickly through this, but this is a picture of the Whispering Winds Golf Course, and the red spots that you see here on the map are proposed soil samples as part of this soil plan. Additionally, the black and yellow here are where we're proposing to install 2 groundwater monitoring wells. The blue triangles, it may be kind of hard to see, but these are sediment samples that are proposed as well. This is a picture of the former sewage lagoons from the RIWP. The purple spots that you see are proposed soil boring sites. So that would be a soil boring of 0 to 50 feet to sample the soil for contamination in that area. This is being done under the RIWP, but it's not a current discharge site as I previously stated. And then this is a photo of the North Playa Lake area. So the red spots that you see around the perimeter of the lake are proposed soil samples to determine the extent of soil contamination here. And the blue triangles are sediment sampling. And this is the wastewater treatment plant outfall. And there's another sediment sample up here. So as you can see, the Air Force has taken pretty extensive steps under its CERCLA response to complete a soil investigation. Condition 49 of DP 873 unnecessarily duplicates those efforts, and the requirement under DP 873 to sample at areas that are not current discharge areas is an attempt to regulate past discharges, and that more properly falls under the CERCLA statutory regime. I'll also touch on condition 50. So condition 50 triggers a requirement for corrective action if Canon goes above certain levels under 20.6.2.3103 for the constituents listed there. This condition overlaps with CERCLA as it pertains to PFAS constituents because the entire purpose of CERCLA is to do remediation projects to abate water pollution that's caused by PFAS contamination of groundwater. So for this reason, condition 50 should be removed from the permit. And lastly, conditions 51 and 52 pertain to monitoring well placement and construction. Just want to point out that monitoring wells are being constructed in accordance with state, county, and Canon Air Force Base requirements under the RIWP. So the RIWP addresses the concerns that are trying to be, that INMET is trying to address through DP 873. And therefore those requirements are unnecessary. So as you can see from this discussion, there are multiple conditions within DP 873 that overlap with the Air Force's work that it's doing under the CERCLA response. And as I stated earlier, this is a problem from both a practical perspective and also a legal perspective under CERCLA 121E. For that reason, these conditions should be removed from the permit. Next, I'll talk about conditions that overlap with the hazardous waste permit. So the New Mexico statute 74-6-12 contains an exemption from the Water Quality Act for an activity or condition that's already subject to the authority of the Hazardous Waste Act. There's a couple of conditions within the permit that would qualify for this exemption. So conditions 63 through 66 of DP 873 are requiring closure actions. And they're requiring closure actions for wastewater treatment plant components that are already regulated under the Hazardous Waste Act permit as Storage Waste Management Unit number 102. So for that reason, those conditions should be removed. Additionally, condition 29 of DP 873 requires groundwater samples to be collected from monitoring wells. And under the RCRA permit, groundwater samples have already been collected from 11 monitoring wells, and those samples were analyzed for volatile organic compounds, metals, and water quality parameters. And so for that reason, condition 29 overlaps with the hazardous waste permit and should be removed. And then we already talked about condition 50, which requires corrective action. This could potentially also overlap with the Hazardous Waste Act permit for constituents other than PFAS, because the hazardous waste permit for Canon also contains corrective action measures for constituents that are hazardous of the PFAS. So for that reason, based on New Mexico's own statutory exemption, these permit conditions should be modified or removed from the permit. And then lastly, I'm going to touch on New Mexico's reliance on guidance to set an enforceable standard throughout the permit. So throughout the permit, New Mexico references InMed's Table A1 of InMed's risk assessment guidance for site investigations and remediation. And the levels within this risk assessment guidance document are used in conditions to say, for example, if you exceed the levels listed in Table A1, you'd be required to do corrective action or your sampling schedule would change. And so it's sort of being used in a way that makes it look like it's being used as an enforceable standard that can and can't cross without having additional actions being required under the permit. However, this is a problem because the risk assessment guidance specifically states that it is a guidance document. This guidance document is intended to clarify a regulation, but it's not intended to be an enforceable standard. The guidance document states, it's important to note that soil screening levels do not in themselves represent cleanup standards, and the soil screening levels alone do not trigger a need for a response action or define unacceptable levels of contamination in soil. The document further states that the exceedance of a soil screening level does not necessarily indicate that current conditions are not safe or that they present an unacceptable risk. Rather, a site risk calculation that exceeds a target value may simply indicate the need for further evaluation or refinement of an exposure model. So the guidance document itself states that it should be used for guidance and the numbers are not definitive. Therefore, the conditions that rely on this guidance document to set an enforceable standard, which are 6, 39, 44, 49, and 50, should be removed from the permit. At this point, I'm going to turn it over to my colleague, Major Threats, who's going to address our final argument related to sovereign immunity.
Good afternoon, commissioners. My name is Major Threats, and I'm here to talk about sovereign immunity. In short, New Mexico Environment Department conflates the issues of preemption and sovereign immunity. As we've explained in our legal briefs, preemption and sovereign immunity are two very distinctly principles, and the lack of preemption does not waive the federal government's sovereign immunity. Only Congress, with an explicit waiver in the statute, can waive that sovereign immunity. And as New Mexico has conceded in their briefs, the closest federal statute to this is the Clean Water Act. And as New Mexico has said, it does not apply to groundwater in this particular case. When we're looking at sovereign immunity jurisprudence in the context of a state permitting action, we look at those specific provisions, not necessarily the permit as a whole. And here those contested provisions specifically call for the investigation and cleanup of PFAS impacted groundwater from past activities which the state attempts to regulate under the state's discharge permit. And as we've noted, there is no applicable sovereign immunity. In order to waive sovereign immunity, the state must point to a specific statute in clear language where Congress has waived that sovereign immunity. And throughout the briefs and negotiations, we haven't heard that at one point. And although our work is incomplete at this point, we were investigating other matters of past permits issued by NMED. And looking at these, we would be able to see whether or not Canon Air Force Base has been unfairly targeted with this particular permit. And when we're looking at sovereign immunity as a whole, in virtually every statute, the federal government, or specifically Congress, makes it clear that sovereign immunity is not waived when a state or party unfairly targets the federal government. And additionally here, we aren't challenging the commission's authority in this proceeding. We submitted our permit for review and appealed it, but we're just challenging those specific provisions which we believe are questionable. And we're challenging those under various arguments, not just sovereign immunity.
So in conclusion, as you can see from our presentation today, the Air Force is taking extensive steps to address PFAS contamination at Canon Air Force Base. And many of the steps that we're already taking overlap with what is required under DP 873. So for these reasons and the additional reasons that I laid out, the Air Force is requesting that the Water Quality Control Commission reverse or in the alternative modify DP 873 under the authority granted to it on 20.1.3.16 F3 INMAC. Thank you for your time.
Mr. Atencio, it is 9:45. Are you ready to begin?
Yes, Mr. Hearing Officer, thank you.
Are you reserving any time for rebuttal?
Mr. Hearing Officer, I'd like to 5 minutes. Roll.
I think it was hard to understand you, but I think you said you want to reserve 5 minutes.
Yes, sir.
Okay, before you begin, Mr. Atencio, do any of the commissioners have any questions for the petitioner's counsel at this point?
Looks like Commissioner Brancard, did you have a question?
I guess I just want to understand the process. Are we doing questions for each party, or are we doing questions at the end, or how are we doing this?
The way it was agreed to at the last WQCC meeting was that the commissioners have the ability to ask questions during oral argument. It doesn't add time to the party's 45 minutes. And since the Air Force finished early, I thought it would be a good opportunity for anyone who might not have understood that to ask questions of the Air Force Council at this point.
Well, I can ask questions just to liven things up.
Please.
All right, thank you. I'm not sure where to start with this. I guess I'll give you my background on this, which makes this all just seem rather, I don't know, unnecessary, I guess is the word. I've spent well over a decade negotiating CERCLA enforcement on behalf of the state at what is known as the Cuesta mine. Prior to the CERCLA action, the state had extensive permits on the Cuesta mine, both discharge permits and permits from my department's mining division. Each of those permits had detailed, approved closure and cleanup plans. We're talking cleanup into the hundreds of millions that was required by the state. We went through the entire process, CERCLA process, with EPA. I mean, the whole alphabet soup, RIFS, RD, RA, ROD, through a partial consent decree. And never once were the state permits challenged by the EPA. And in fact, the state permits are still there. The reason for that is that the EPA brought the state in to the CERCLA process, and the state essentially became a partner in the CERCLA process. So the end result of what EPA came up in terms of a cleanup looks a lot like what the state was requiring under its permits. So I guess I'll start off by the confusion about why hasn't the Department of Defense brought the state into the CERCLA process?
Thanks for your question, sir, and I appreciate the explanation of your background. That's interesting. So I would agree there is a place in the CERCLA process for state involvement, for sure. But the arguments that we've heard from InMed on this issue are that they're not acknowledging our CERCLA response. If you look at New Mexico's answer brief to our opening, they state when they address our CERCLA response that it's a CERCLA-like response, because it seems from the New Mexico brief that they preferred this be regulated under a RCRA statute. And so I do agree with you that there is a point in the CERCLA process where the state should be brought in and consulted, but the way that these arguments have panned out, it seems like the state is not really willing to acknowledge the CERCLA response that we're doing in this proceeding, at least.
Well, I guess I would urge both sides to try to figure out a way to work together here. I mean, when the United States sued the mine owner in sort of a perfunctory suit to get our partial consent decree approved in the CERCLA process, the final step. The state was a party to that litigation because the state was a partner to the cleanup action. So that's really what should go on here. Of course, in this case, DOD would be suing itself if it went to court. But anyway, let me ask some basic questions. I haven't not looked at the record in detail, so I'm sure the answers are there that I'm just missing. Is Canon Air Force Base or any portion of Canon Air Force Base on the national priorities list?
No, sir.
Okay. Does the discharge permit that the Environment Department or the proposed renewal of the discharge permit, which is what we're talking about here, really, does it include an abatement plan under Section 4000 of the groundwater protection regs?
So condition 50 of the permit would potentially trigger abatement plan requirements if the levels were exceeded in 20.6.2.30 103 NMAC. So it doesn't require an abatement plan outright unless certain thresholds are exceeded, is my understanding, if I'm understanding the question correctly.
Yes, thank you. Okay. I guess I'll just say, here's my understanding based on my experience with CERCLA of what CERCLA 121E applies to. You know, you're not at the remedial action phase here. You're still in the RI phase. Then you got to go through the FS and then the RD before you get to the RA. Okay. I mean, the 121E, as we interpreted it and as EPA interpreted it, has to do with whether, say, a remedial action requires a wastewater treatment plant, and then the local government steps in and says, no, you need a zoning approval for that, and you need a construction permit and all that. It was not ever interpreted, in my experience, as applying to the actual state environmental regulation of the same facility. It was instead to other kinds of permits that would apply to the actions that is required under CERCLA. I mean, is anything the Environment Department doing prohibiting you from taking the actions under your CERCLA permit?
I would say that what the discharge permit does is potentially slow down and complicate our CERCLA response in a way that would essentially lead to INMED dictating our CERCLA response. So for example, we're doing the soil investigation under the RAWP. We have a soil investigation requirement under condition 49 of the permit. If, for example, New Mexico doesn't agree with the sampling methods that we're using, and they're coming back and saying, no, we need you to change these sampling methods, then we're essentially letting New Mexico Environment Department dictate our CERCLA response, which doesn't line up with the authority that we've been given under the executive order to be the lead agency here. And I'm not opposed, like we're not opposed to having state involvement in the CERCLA process, but that's just not currently how it's playing out.
Okay. Let me just finish up by asking about the sovereign immunity argument. And I guess, let me ask the dumb question. Immunity from what?
Immunity from enforcement under the particular DP 873, Commissioner. In order to necessarily consent to monitoring or supervision, there has to be some waiver of sovereign immunity. And NMED and both the Air Force acknowledge there is an applicable statute where there is that waiver of sovereign immunity in order to allow New Mexico to enforce these terms against us.
Well, I mean, I guess, you know, my limited legal background, I would say that immunity, I always assumed was immunity from lawsuit. And what you all seem to be talking about is more of lack of jurisdiction of the state to regulate a federally owned and federally operated facility. Is that what you're claiming?
Yes, Commissioner. like in the Clean Water Act, when we waive sovereign immunity, we waive essentially our ability to be sovereign. We allow the states to have oversight under the Clean Water Act. And there's very specific language in there which says what will waive our sovereign immunity for, what will allow the states to do for us. And under the Clean Water Act, we essentially comply with virtually all the provisions in the Clean Water Act. Whereas we sought out, at least, and made an attempt to see what InMed applicable sovereign immunity argument has been in order to govern us on this particular DP 873. And we've only heard from InMed that it's fairly preempted, or there is no federal preemption. And we've tried to communicate several times with the state that preemption and sovereign immunity is different. We haven't necessarily consented as a sovereign to be governed under this particular act. And absent Congress waiving that sovereign immunity, we aren't necessarily governed by it.
Okay, so is the real legal issue the fact that this federal land is federally operated? In other words, the state of New Mexico regulates lots of facilities on federal land. My department regulates mines, oil wells, thousands of them on federal land. But this facility, without any explicit waiver of anything, it's just, you know, and there is some federal regulation going on. It's viewed as concurrent regulation. We try to get out of each other's way, but is the real issue then here because it's the federal government that's operating this facility?
Yes, Commissioner, the issue is that it's the federal government. And as we've kind of reiterated, only Congress has that authority to waive sovereign immunity for us. Even as the Air Force, we can't decide that, hey, it would be good to play with New Mexico in this particular instance and work towards a resolution if Congress hasn't given us the explicit authority.
Okay, thank you. That's all my questions for now.
Okay, before we take any more questions from commissioners, I would like to get a stipulation from the parties because at this point it is 10 a.m. and the Air Force has used 40 of its 45 minutes for its oral argument. It has reserved 5 minutes for rebuttal. And we've limited each party to 45 minutes. So if the commissioners would like to ask more questions from the Air Force, since their time is up, would the parties agree to an additional 15 minutes, potentially, if the questions go that long, to answer these questions at this point? Petitioner?
There's no objection from us, sir.
From NMED?
Mr. Hearing Officer, no objection, provided that the same courtesy is extended.
Of course, Mr. Atencio. Okay, commissioners, that gives us up until 10:15 for any questions. If that time's not used, then it'll be forfeited. I see Commissioner Dominguez, but I also see, are there any other commissioners besides Commissioner Dominguez who had their camera on first? No. Okay, Commissioner Dominguez?
Thank you, Mr. Hearing Officer. Good morning. Thank you for your testimony. I'll try to get through some questions fairly quickly here. To follow up on the prior questioning on sovereign immunity, just so that I have a better perspective of it here. If I understood correctly, it's related to the objection there is it's related to the permit itself, that the oversight and enforcement of the discharge permit itself. Is that correct?
That's correct, Commissioner Dominguez.
Okay, refresh my memory, although I'm sure it's in the administrative record. This is not the first time this permit was renewed. When was the first permit issue to Canon Air Force Base?
It was issued in 1994.
And at that point in time, did Canon Air Force Base raise the issue of sovereign immunity?
They did not, Commissioner, but I think the difference is that the practical reality is that this particular permit is significantly and fundamentally different than all prior iterations of this permit.
Is that primarily because prior to this permit renewal, there were not detections of PFAS on the base?
Yes, Commissioner, there wasn't extensive monitoring requirements and sampling requirements of PFAS required under the DP 873 until this particular permit iteration.
So then if I'm putting the pieces together, it's not necessarily the discharge permit itself, it's the oversight of anything related to PFAS.
Honestly, I think at the time, whoever was in charge, 94 or prior, I can't speak for them. I believe they had the authority to challenge those particular provisions as violating sovereign immunity. They just chose not to because it wasn't entirely overly burdensome and it wasn't necessarily a major conflict with the current state of the federal law. I think once this particular permit with the extensive soil sampling requirements, PFAS monitoring, and we had already expended $32 million on our circular response. Once that was at play, I think it was more apt for the Department of Air Force to assert its sovereign immunity.
Okay. Let me turn to CERCLA. Your actions under CERCLA only pertain to on the base, or does that pertain to anything that drifts off base?
So the CERCLA investigation does include sampling of off-base areas in the vicinity of Canon Air Force Base. That's how we know if certain off-base drinking water was contaminated with PFAS, PFOA above the lifetime health advisory, and then those people were provided alternative drinking water. So it's in the vicinity of the base, but we will include some work. It doesn't have to be entirely within the boundaries of Canon.
And if I understood your response there, that was just for sampling, not for any type of cleanup.
Well, I think the reason my answer pertains to sampling is because we're still in the investigation phase. So later on, when we'd get to determining what the actual remedial action is going to be, at that time there would be a determination of what action would be taken. But I can't speak to that right now because we're not at that phase yet. But I think that there's a potential that it could require action.
And I think to my point, Environment departments and ultimately Water Quality Control Commission's responsibilities deal with all groundwater. We're responsible to groundwater for all people in the state. So the permits that are issued don't have a boundary drawn around them. And I think that may be a little bit of where we see some differences of opinion. And you've, in your brief, you've referred to the CERCLA exemption that's within 20.6.2, correct?
Yes, sir, that's correct.
And if I understood your testimony today, Air Force has the authority over this CERCLA activity, and there is no oversight by EPA, correct?
Well, I would say that there is involvement from EPA. So EPA does receive copies of our work plan and they have an opportunity to comment. And as you may remember from my presentation, I stated that the Remedial Investigation Work Plan report will be completed in general compliance with EPA guidance. So I don't want to paint a picture of saying the Air Force is the only agency that makes decisions here and we don't take input from other agencies. We do involve EPA in this process. So I think that's an important point to make.
Let me rephrase my question then. Does EPA have oversight authority for CERCLA?
No, sir.
Emphasis on the word authority.
No, sir. They do not have oversight authority. I believe, though, that the INMAC uses the word under the authority of EPA, so I'm not sure how much of a difference that makes, but you're correct that they don't have oversight authority. However, I would also want to point out that the president did delegate authority to the Air Force as the lead agency. So our authority is on par with EPA, which is another federal agency.
Is that language captured within 20.6.2? Or is it just specific to EPA?
20.6.2 just states under the authority of EPA. It doesn't say anything other than that, but practically speaking, it seems to be a bit of a distinction without a difference because we are involving EPA in the process and we have been delegated authority by the president as lead agency on par with EPA.
Do the courts provide this commission the authority to interpret and extend a law or regulation, or are we bound by the language of the law or regulation?
The commission's attorneys.
I'm not sure. Sir, I'm not familiar with case law that's directly on that point, but I would say that if you look at our brief where we talk about the terminology that's used, again, it seems to be kind of a distinction without a difference where perhaps the commission could use common sense to see that our authority is on par with EPA because we've been delegated that authority by the president.
Okay, I understand the response. In the sake of time, in case there's other commissioners that have questions, I will cut off my question there. Thank you for your testimony.
Commissioner Thompson?
Yes, thank you. You stated earlier that if a public water supply is impacted, the Air Force will immediately replace that water supply, make them whole. My question is, what about offsite contamination of non-potable water supplies? For instance, for agricultural activities. Will you also provide a water supply for a dairy farm or a farmer?
Sir, I don't believe that we would provide an alternate source of water for agricultural purposes. I want to just state that, like, again, how I said in the presentation, what's been done is for addressing drinking water, and that's our most important priority because we want to make sure that human health is not put at risk by drinking water above the EPA lifetime health advisory. I actually could double check on that on the agricultural issue, just an email back to the commission with Mr. Atencio CC'd. I don't believe we would provide an agricultural source of alternative water, but I will double check on that and get you an answer. But initial thought is no.
Thank you.
You're welcome.
Mr. Commissioner Dominguez, does that leave you with another question?
Just a quick follow-up to Commissioner Thompson's question.
Please.
So with that, because you've focused that you're concerned of human health, so back to the example he used. So if we've got contaminated milk supply due to contaminated cows, due to cattle drinking contaminated water, then there's not a concern for the human health on milk that's consumed by those humans, only if they're drinking water. Am I understanding you correctly?
I was having trouble unmuting. I wouldn't say that we don't believe there's a concern to human health. We're just operating within what the statute spells out and what the statute requires. The statute addresses drinking water sources. And so we're bound by the constraints of the statutory layout. But I don't mean to say that the Air Force is not concerned about anything other than drinking water. We understand that it may be a health concern, but we're bound by the statute and what it lays out for how we prioritize things. And we prioritize drinking water above other sources.
Even though that drinking water is just done with a health advisory, not an enforceable standard, correct?
Yes, sir. The EPA Lifetime Health Advisory is just an advisory. It's guidance. It's not an enforceable standard.
Okay, thank you, Mr. Hearing Officer.
If there are no other questions from commissioners, I have a quick question for Major Threats, or is it Threats?
It's Threats, Hearing Officer.
Thank you. Thank you, Major Threats. Is there a distinction when you turned off your camera, Major Threats? Would you turn it back on? Thank you, sir. Is there a distinction legally when it comes to sovereign immunity for conditions that occur within the base to things that are done on the base that could and do leak off the base and impact the surrounding areas?
No, Hearing Officer, there is no distinction.
So sovereign immunity would still, in your argument, prevent the state from regulating activity on the base, even if it were shown to affect the surrounding communities off the base. Is your answer?
Under the DP 873, not necessarily if there was a Clean Water Act waiver or something of that nature, or an applicable RCRA waiver, just on the particular DP 873, where there is no waiver of sovereign immunity. So under other regulatory schemes, there are opportunities for us to handle things that occur off base and may impact things off base.
Thank you, sir. Okay, it is 10:14. We are at the limit of the stipulated time extension for the petitioner's oral argument. They have reserved 5 minutes for rebuttal. Mr. Atencio, are you ready to begin?
Yes, Mr. Hearing Officer.
Are you sharing your screen?
I will not be.
You will not be. Okay, please proceed.
Thank you, Mr. Hearing Officer. Chair Stringer, members of the commission. Thank you for your time and attention today. While this matter seems to be complicated on the surface, the questions that you're being asked to decide this morning are not as complex as they may seem. The distraction of the existing PFAS contamination in and around Canon Air Force Base is not what is at issue here. And just as an aside, I may refer both to PFAS and PFCs, or perfluorinated compounds, as the Bureau tends to do in its documents interchangeably throughout this discussion. The issue is that Canon Air Force Base is discharging PFCs from its wastewater treatment plant. This is a concern for the Groundwater Quality Bureau, and it has taken steps through DP 873 to regulate this discharge in a way to avoid further contamination of the groundwater in and around Canon Air Force Base. The Air Force attempts to impose the remedial actions of its CERCLA-like response on the discharges from its wastewater treatment plant. However, it has not demonstrated how CERCLA controls discharges from its wastewater treatment plant. Rather, it's been significant time discussing the aspects of the CERCLA-like response at other portions of the base in an attempt to avoid precautionary conditions found in the groundwater discharge permit. Contrary to its assertions, Canon is asking for special treatment rather than listening to the department's concerns regarding the discharge from its wastewater treatment plant. The Air Force repeated its line that CERCLA prevents oversight. The department disagrees. There may indeed be overlap between the actions that Canon does take or decide to take at CERCLA-like response and the conditions of the permit, but just because the activity touches on multiple legal areas does not mean that it forecloses certain regulations. The discharge permit conditions are very specific to the wastewater treatment plant discharges. The bottom line is that the department followed the correct procedural requirements for issuing this discharge permit. The department adequately supported the conditions that it wrote into the permit. The department considered the comments from the Air Force and made changes based on those comments while rejecting other recommendations from the Air Force. The basic requirement in this situation is that no person shall cause or allow effluent or leachate to discharge so that it may move directly or indirectly into groundwater unless they are discharging pursuant to a discharge permit issued by the Secretary. If the discharge will not result in a hazard to public health or undue risk to property, the department shall issue the discharge permit. We find that in 20.6.2.3109C. But the discharger must demonstrate that the discharge will not result in concentration in excess of 3103 standards. There is no federal counterpart to New Mexico's groundwater regulation. The Clean Water Act focuses on surface water. However, the vast majority of New Mexico's public water supply does not come from surface water. It comes from groundwater. And that is why protection of groundwater is so extremely vital in this situation. That is why the department tailors each groundwater discharge permit to the specific circumstances of that discharge. That is why no discharger, whether state government, private entity, or federal government, is above this requirement. However, in this situation, the United States asks to be exempt from this requirement based on its own determinations. The United States is demanding that because it is addressing some of its past contamination events through a CERCLA-like process, it should not have to ensure that its wastewater treatment plant does not cause its own further contamination. This matter is a permit review. In this proceeding, the department is required to provide a factual and legal basis for its decision. It must show that each condition within the groundwater discharge permit is reasonable and necessary to ensure compliance with the Water Quality Act and with 20.6.2, considering the site-specific conditions. You, the Commission, must determine if the department's action was arbitrary or capricious, an abuse of discretion, or not supported by substantial evidence in the record, or otherwise not in accordance with law. And not in accordance with law means that the department has unreasonably or unlawfully misinterpreted or misapplied the law. Following your review of the record and the arguments presented, you may sustain, modify, or reverse the department's actions. I won't go too far into depth regarding the background of this permit, but in this proceeding, it was initiated by the United States filing an application for renewal of the groundwater discharge permit for Canon Air Force Base, or DP 873. During the permitting process, the applicant or the permittee, as well as the public, have the opportunity to submit comments on the draft discharge permit that the department has prepared based on the information provided by the applicant. The regulations allow for 30 days for comment in that process. In this instance, the department provided 90 days for comment. the United States commented on the draft discharge permit, and as the record shows, the Bureau replied to each of those comments. Most importantly, the permitting process allows the permittee the opportunity to request a permit hearing where it can present evidence as well as cross-examine the Bureau's technical staff regarding the permit conditions. Many of the arguments briefed in this proceeding could have been more fully presented at such a hearing. However, rather than engage in a permit hearing, where it could have presented evidence and cross-examined the Bureau's witnesses, the United States seeks to invalidate permit conditions after the fact. In all steps, the Bureau followed the applicable administrative process for issuing the discharge permit. The United States had the opportunity to participate in this process and chose to exercise some of those options and not exercise others. Uniquely in this permit, Canon has documented contamination in and around the base. There are only 2 sites in the state of New Mexico that have documented high levels of PFCs in their groundwater. One of them is Canon Air Force Base. The other is Holloman Air Force Base. Importantly for this discharge permit, the United States' own sampling indicates PFHXS, PFOS, and PFOA in both the influent to the wastewater treatment plant, as well as the effluent coming from the wastewater treatment. As you are aware, the Commission only added PFCs to the list of toxic pollutants at the end of 2018. Up to that point, there was no regulatory provision addressing them. Since then, the Bureau has been working to implement its permitting program, implement these standards in its permitting programs. Thus, PFC testing requirements and permits where the permittee is likely to encounter PFC contamination only began in 2019. The site-specific data in this instance dictates that additional protections are necessary in the permit. Other facilities around the states have not documented such extensive contamination. Indeed, you heard quite a lot about the investigation that the Air Force has undertaken at Canon Air Force Base. Other facilities have not undertaken such an investigation or is nearly far along in determining the presence of PFCs at their sites. So while the Bureau can certainly require testing to determine the extent of contamination, if any, at those sites, the data at Canon dictates that the Bureau requires specific conditions related to PFCs. If those other sites, as they continue on in their investigations, show similar data, then likely those sites may require additional permit conditions when they are reviewed. You heard earlier that the department does not agree that CERCLA controls in this situation, and that is correct. As the record shows, documented contamination in source water, documented contamination in influent, and documented contamination in effluent all support the Bureau's decision to include the permit conditions at issue. That's the focus. The United States has devoted extensive time to outlining its processes that it is undertaking in its CERCLA-like activities to address the existing contamination at Canon. However, as the Bureau stated in its response to this argument, the DP is focused on existing discharge that contains PFAS, not the existing contamination on other portions of the base. That is being handled in other areas. There are investigative requirements related for discharges related to the wastewater treatment plant, but no other remedial requirements in that situation. The actions that the United States explains in its comments, as well as the information that it provided at the time, does not indicate that the CERCLA-like action would cover the wastewater treatment plant discharges. Thus, CERCLA is not applicable. There is no need to delve into the weeds of CERCLA law when there's that distinction. The burden is not on the department to prove a negative. Rather, the United States must show that discharge from its wastewater treatment plant is a removal or remedial action under the authority of EPA, and it has. As I mentioned, not in accordance with law means an unreasonable or unlawful interpretation of the law. The Bureau has first distinguished the 2 ongoing actions. Second, the United States has determined that CERCLA is appropriate for the contamination on site. The department hasn't. For instance, the United States argues that condition 26 of the permit requires installation of 4 monitoring wells. While the United States is choosing to install 26 monitoring wells as part of its CERCLA-like response in the same area, the United States argument seems to be that because it is pursuing remediation under one legal arena in that physical location of the base, any other regulatory the regulatory requirements are automatically precluded. Throughout this proceeding, there has been, the United States has ignored the fact that it can install as many wells as it wants pursuant to its circle-like process and that other remedial activities. But that doesn't relieve the need to satisfy the Water Quality Act. Those circular wells can be put in place outside the scope of the groundwater discharge permit. But at some point, monitoring wells for the groundwater discharge permit must be installed. Understandably, a permittee may not want to spend extra time or money to install more wells than is needed. This is why the Bureau has consistently stated that the circular wells can be used to satisfy the DP 873 requirements. But if the United States chooses to do so, those wells must meet the Bureau's requirements before they can satisfy DP 873. This is the same situation with the groundwater sampling. DP 873 does not control when or where the United States chooses to sample groundwater in its other activities. But if the United States chooses to use those sampling actions to satisfy DP 873, they must meet the Bureau's requirements. This extends to many of the supposed overlaps that the United States argues. But the action that the Air Force highlights are all related to the broader existing contamination at the base, not the wastewater treatment plant discharge. Now, much of the discussion focuses on the current discharge, but should that discharge lead to further contamination, DP 873, as with all permits, requires corrective action in certain circumstances. The United States claims that it is entitled to an exemption from such requirements pursuant to 20.6.2.4104A. But even if CERCLA were to control, the record does not demonstrate that the United States is entitled to an exemption from abatement requirements. Indeed, the Bureau has not determined that abatement is required at this point. Thus, it is impossible to say that an abatement action as required by the Bureau is being conducted pursuant to CERCLA if there is no abatement action to compare the Air Force's action. Again, the Bureau has not required a Stage 1 abatement plan, nor has the United States voluntarily submitted one. Thus, regardless of how similar CERCLA-like actions may be, abatement has not been triggered as defined in 20.6.2. Still, even though this discharge permit is not focused on remediation of the existing contamination, exemptions under the abatement exemptions are not absolute. If the abatement will not meet the correct standards, the exemption doesn't apply. We see that in 4105B. Again, the Bureau cannot make that determination because it is not required to abate. If the Bureau were to require abatement, the circumstances of that specific situation would determine if exemption were appropriate. And that process would also be subject to public notice and the opportunity for a hearing process. These conditions are put in place to ensure groundwater protection. The United States seems to ignore the possibility and claim that the possibility of PFCs entering the wastewater treatment plant have been mostly addressed. While no one here wants the wastewater treatment plant process to fail, it may. Further, the United States' own sampling indicated PFCs in the wastewater treatment plant inflow. Further, NMED has interpreted the plain meaning of the regulation to be that any CERCLA action must be under the authority of the US EPA. The United States continues to argue that operating under its own authority is the same as operating under EPA's authority. However, all the Air Force has shown is that EPA's role is limited to comments on its actions. Thus, it is not clear to the Bureau that EPA has authority over this CERCLA action. The Commission clearly stated its two-part test for this exemption in the regulations that it promulgated. First, that the action was pursuant to either CERCLA or RCRA, and second, that it was under the authority of EPA. To find that only CERCLA was required without EPA's authority would not give effect to the full regulation. Therefore, that exemption is not appropriate, nor is removal of this condition. Let me turn to the contamination and numeric standards. As the Commission knows, it has promulgated numeric standards and narrative standards in Section 3103 of the regulations. While the numeric standards have a specific number already determined by the WQCC, the narrative standards do not. Rather, the narrative standard for toxic pollutants is that they shall not be present at a concentration shown by credible scientific data and other evidence appropriate under the Water Quality Act, currently available to the public, to have potential for causing one or more of the following effects upon exposure, ingestion, or assimilation, either directly from the environment or indirectly by ingestion through food chains. And those are unreasonably threaten to injure human health or the health of animals or plants which are commonly hatched, bred, cultivated, or protected for use by man for food or economic benefit. As used in this definition, injuries to health include death, histopathologic change, clinical symptoms of disease, behavioral abnormalities, genetic mutation, physiological malfunctions, or physical deformations in such organisms or their offspring, or creates a lifetime risk of more than one cancer per 100,000 exposed persons. While this standard does not state an exact concentration, it establishes the framework to determine what that concentration should be. This is the standard the Commission has set. The Bureau has not made such a determination for the 3 PFCs listed as toxic pollutants in the regulations. However, the Bureau has included Condition 50 within the permit to address contamination of any of the 3103 standards, not just PFCs. And paraphrasing, that condition states that if groundwater monitoring indicates an exceedance of a standard under 3103, the permittee has to conduct a confirmatory sample, and then, if confirmed, submit to NMED a corrective action plan, which includes at a minimum contaminant source control measures and implementation schedule. The Air Force appears to argue that this is an automatic abatement trigger, but as written, there's nothing in this condition that requires immediate abatement. Indeed, there are at least 2 steps for contamination that includes toxic pollutants with narrative standards. First, the department would need to determine the appropriate concentration. Second, the department would require corrective action. Only if and after corrective action proved insufficient would abatement be required. While the United States may find the regulations supporting this permit condition frustrating, this condition essentially mirrors the regulations. Currently, the department is using a screening level developed by the risk assessment guidance document, but as stated, this level is not a corrective action trigger, nor is it a cleanup trigger. It is a testing and reference level. And there is a difference between requirements and standards. The United States had the opportunity to contribute to developing a different screening level, but the response has consistently been that unlike the rest of the state, Canon Air Force Base needs less oversight, not more. Further, the Bureau's determinations once made are not without recourse. As the Commission is well aware, there are opportunities for public hearing and appeal at nearly every step of the abatement process. Therefore, the United States arguments as they pertain to abatement for any of the PFC contamination are premature, and the recommended solution of removing corrective action requirements from the permit would result in less oversight of the discharge. Turning briefly to financial assurance, requiring financial assurance is within the discretion of the department. Now we find that in section 3107A11. It is not contrary to logic or reason for the department to require financial assurance. Nothing in the regulation indicates that federal facilities should be excluded from this requirement. NMED does recognize that some facilities are differently situated than others and modified the financial assurance condition in this permit based on the Air Force's comments. This fits squarely with the department's need to assure that the conditions are related to site-specific conditions of each permit. Again, the Air Force asked for special treatment by arguing for less oversight as its solution. And briefly touching on the sovereign immunity argument, the department finds it difficult to make sense of the sovereign immunity argument as presented by the Air Force, because it appears that the Air Force is cherry picking when and where sovereign immunity should or should not apply. This permit has been in place since 1994, and it appears that this argument raises whenever it is convenient. In this case, dealing with a toxic pollutant that has the potential to injure human health and the environment. In conclusion, I wanted to thank you for your time and attention. This matter does not need to be complex or particularly confusing. The Bureau is required to protect groundwater through the issuance of discharge permits, and while it has the discretion to craft permit conditions that fit each situation, it does not have the authority to ignore contamination wholesale. As you heard, the statute the Air Force operates under limits its action, leaving large areas with no recourse to that circular-like action. leaving little recourse outside the bounds of the statute as described. This is of great concern to the Bureau. Please keep in mind that there is an ongoing discharge from Canon Air Force Base's wastewater treatment plant, and that discharge, according to the sampling, contains PFCs. The Bureau has drafted a discharge permit that contains conditions designed to monitor the discharge from the treatment plant. In issuing this permit, the Bureau followed all the necessary procedural steps. For these reasons, I respectfully request that you sustain DP 873 as issued by the Department. Thank you.
Are there any questions from commissioners for Council Atencio? Yes, Commissioner Thompson.
Thank you, Mr. Hearing Officer. Mr. Atencio, throughout your presentation and also the documents that were provided to the commission, you refer to the Air Force's activities as CERCLA-like. Can you tell me how they are different from the remediation investigation activities that would be conducted under a formal CERCLA process as administered by EPA?
Commissioner Thompson, Chair Stringer, Mr. Hearing Officer, thank you for that. The Department interpreting the actions of the Air Force notes that, as is noted at this hearing, that the site is neither listed on the national priority list, nor is it being remediated under the authority from EPA. So while it maintains similarities, those two key components seem to be missing in this situation.
And so, just to follow up a little bit, the activities themselves are consistent with what would be done at an NPL site or a CERCLA site. It's just the administrative oversight that you're concerned about?
Commissioner Thompson, members of the commission, I don't know that I'm necessarily prepared to say whether their actions comply with CERCLA or not, except for those two regards. The department's position has been that CERCLA has not been shown to apply in this particular instance, which the record was limited to. In other arenas, the department has disagreed and maintained that RCRA, the Resource Conservation and Recovery Act, is the appropriate mechanism for those activities.
Thank you.
Commissioner Dominguez, did you have a question?
Thank you, Mr. Hearing Officer. I think Commissioner Thompson pretty much covered an area I had in mind. Thank you.
Thank you. Commissioner Brankard?
Okay, just one question maybe. So I have not read the discharge permit. I apologize. Is there a specific provision in the discharge permit that recognizes the ability of the Air Force to use its work under this process, this CERCLA-like process, in lieu of requirements under the discharge permit?
Commissioner Brankard, members of the commission, that information, I believe, is contained in the response to comments, not necessarily within the verbiage of the permit itself, but the responses that were sent out when the permit was issued.
Okay, just one follow-up then. So I think it was said that the Air Force is putting in 26 monitor wells. The Environment Department wants 4 more monitor wells. If the Air Force agrees to do the 4 more monitor wells under its CERCLA-like process, would the discharge permit be modified?
Commissioner Brankard, members of the commission, my understanding from the Groundwater Quality Bureau staff is that if those wells were placed in both a location and in a manner that was consistent with the requirements of the permit, the Bureau has no problem with them satisfying both the CERCLA-like process and the permit. But if those wells are not placed in the correct location, they would not provide the correct data that would be necessary for monitoring under the permit.
Okay, Thank you. That's all I have.
Mr. Hearing Officer, I have a question. Okay, thank you. Thank you, Mr. Atencio. I was wondering, you've explained why it doesn't fall under, in your position, CERCLA. Can you clarify why you believe this is subject to RCRA?
Thank you, Chair Stringer, members of the commission. I might clarify that the department believes that the remedial actions of the extensive and existing contamination in other portions of the base would fall under the RCRA authority. And though not the subject of today's action, the Hazardous Waste Bureau has maintained is that because PFCs meet the statutory definition of a hazardous waste under both the Hazardous Waste Act and RCRA. This facility, the wastewater treatment plant, would fall under the authority of the Water Quality Act.
Yes, thank you. It's an important distinction. I didn't capture in my question to you. Thank you. I do have a question. This is probably more for the Air Force, but I'm just curious as to why they didn't request a hearing during the public comment and opportunity to request a hearing. I understand that a meeting was requested with the department. I don't know if that meeting occurred, but I'm interested to know why a hearing wasn't requested at that time, given the objections that you're presenting now. I don't know if they can answer that, but.
Chair Stringer, the petitioners have 5 minutes of rebuttal, and that question can be directed to them during that time if you would prefer.
Okay, thank you. Yes, I'll save the question for that time.
Are there any other questions for Council Atencio? Hearing none, petitioners, are you ready for your 5 minutes of rebuttal?
Sir, we are ready.
Are you going to be sharing your screen?
No, sir.
Okay. It is 10:42. Please begin.
Okay, thank you, commissioners, for your time. I just want to address a couple of points that InMed's counsel made in their argument. So up front, New Mexico Council stated the importance of their goal to protect groundwater. And I do want to emphasize that this is also an important goal for the Air Force. We do agree that groundwater in New Mexico is very important, and we do agree that it's important to protect that groundwater. So we are undertaking this $32 million CERCLA response and additionally a $16.5 million pilot study to help address PFAS contamination in the groundwater at Canon Air Force Base. And take a second to touch on the pilot study because it goes back to a question that Commissioner Dominguez had earlier in our presentation. So he asked about PFAS contamination that goes off the base, and I wanted to let him know that the pilot project that we're doing on the southeast corner of the base to help speed up removal of PFAS from groundwater is actually placed on the southeast corner of the base to help address migration of this contamination off base. So this is something that we do take seriously, and we are acting to try to remediate under the CERCLA response. Another point that New Mexico Council stated was the point about requesting a hearing. So importantly, I want to just emphasize that under the rules, a hearing request is not a prerequisite for a permit review hearing. And Canon did submit very extensive comments on the draft permit, and they reached out to New Mexico directly and requested that we have a meeting where we could sit down and go through the technical and legal issues that we saw with the draft permit. So Canon did want to work this out prior to issuance of the final discharge permit and did attempt to do so. However, we did not hear back from New Mexico on our request for a meeting or our discharge or our comments on the draft permit until the issuance of the final permit on December 15th, 2021. So there was an attempt to reach out. We did want to work with InMed on it. Unfortunately, we weren't able to sit down with them because our request for a meeting was not granted. And so we needed to proceed with this permit review hearing. Additionally, New Mexico stated that Canon's activities don't meet the definition of abatement for the exception to abatement. However, I want to point out that 20.6.2.7A2 of the INMAC defines abatement as the investigation, containment, removal, or mitigation of water pollution. And I think that based on the presentation I gave today, where we talked about the extensive investigation that we're doing to ultimately mitigate water pollution, we do meet the definition of abatement under the INMAC. However, even if the commission decides that we're not eligible for that exemption, CERCLA 121E does control the situation because it is a federal statute. And so we are exempted from permitting requirements for these remediation actions under CERCLA 121E. I also want to address Council Atencio's statement that New Mexico tailored the permit to address wastewater treatment plant discharges. So as we discussed in our presentation, the DP 873 contains requirements related to the former sewage lagoons and around the wastewater treatment plant. Those are not areas where current wastewater treatment plant discharges are taking place. So the permit doesn't necessarily, in all respects, regard wastewater treatment plant effluent regulation. It contains other requirements that are more remediation related that more properly fall under the circular response. Additionally, New Mexico stated the permit was tailored to regulate the wastewater treatment plant effluent, but at the time that the draft permit was completed and the final permit was issued, the remedial investigation work plan, the preliminary assessment, and the site inspection were not part of the administrative record. So those had not been reviewed by New Mexico Environment Department at that time, as far as we can tell. And so they would not have been apprised of the amount of work that we have been doing since the time of the draft permit issuance to really tackle groundwater pollution through our remedial investigation work plan at Canon. So it's not possible that the discharge permit was tailored to consider those new facts that weren't added to the administrative record until fairly recently. And then finally, I just want to touch on the issue of sovereign immunity. So it is true that Canon has had a version of DP 873 since 1994. However, Canon complied with the permit out of comity up until the point where this most recent version of DP 873 contained conditions that were overlapping with and unnecessarily duplicating our circular response. We could have raised a sovereign immunity defense much earlier in time. Just because we didn't raise it earlier doesn't mean that we waived it. And so Canon is raising it at this point. Overall, I just want to emphasize that the Air Force is taking a lot of steps to address PFAS contamination at Canon. We do take groundwater contamination seriously. It's just that we have to work within the constraints of CERCLA, and CERCLA provides a legal exemption from state permitting requirements that overlap with remediation activities under CERCLA. And so those permit conditions that overlap should be removed from the permit at a minimum. In general, though, we're requesting that the WQCC reverse the permit because there is no federal waiver of sovereign immunity. Thank you for your time. That's all we have.
Mr. Hearing Officer, you're muted.
Thank you. Council Atencio, you have 6 minutes to rebut. Petitioners took an extra minute and I didn't interrupt them, so please proceed.
Thank you, Mr. Hearing Officer. 1 second. Just a couple of points. The Air Force argues that the activities at Canon Air Force Base, the CERCLA-like activities, meet the definition of abatement. And regardless of the similarities to abatement or not, 4100 of the regulation includes specific triggers of when the abatement process starts and begins. Those triggers are important because there are public notice requirements, there are hearing components, there are disagreement provisions built into those regulations. It's not a nebulous, these activities rise to the level. There are specific triggers. In reference to the former sewage lagoons, again, those requirements are investigative, not necessarily remedial in action, but also are related to the wastewater treatment plant, not necessarily the other existing contamination on site. As you heard, the remedial investigation work plan was not part of the record. The department, as it states in the comments, the Groundwater Quality Bureau did not receive that from the Air Force. That apparently was submitted to the Hazardous Waste Bureau. which operates under a different statutory scheme and is not the same as Groundwater Quality Bureau. And even if those activities are, again, show similarities to things that can be done on the groundwater quality discharge permit, that doesn't mean that the condition should be removed, merely that those activities could likewise satisfy the permit conditions if necessary. And I'm sorry for jumping around, but one final point on the requirements for the former sewage lagoons. I mentioned that those are investigative in nature, and those are also not specific necessarily to PFCs. There is existing nitrate contamination in association with the wastewater treatment facility, and so there are more standards in 3103 than just the three toxic pollutants that seem to be the main issue. Thank you.
That concludes oral argument today in WQCC 2101. Chair Stringer, how would the commission like to proceed? Would the commission benefit from a hearing officer's report? And if so, I need to issue a scheduling order with the timelines of that process, which is not spelled out at all in the rule 20.1.3.16, or would the commission would like to proceed to deliberation and a final order?
Thank you, Mr. Hearing Officer. So understanding the discussion that occurred during the last meeting of the commission in July, there was a question regarding the hearing officer report development. In reviewing the record, the order assigning you as the hearing officer does state that we would seek a recommendation from the hearing officer. And so certainly we can open it up for discussion from other commissioners, but I believe we would like to pursue that typical route to kind of get the notice of the transcript, and 30 days from that, get the finding of facts, and then just following the normal orders that we followed historically to get the hearing officer report. Do I have any questions or discussion on that from commissioners? Vice Chair Cipher?
Chair Stringer and my fellow companions, I have been left with a couple concerns. First of all, let me say that, yes, I agree with the process that you just outlined. I think it would be great. But I want to add one other consideration that, or rather a concern I've been left with. It seems to me that there are several potential crossovers to different divisions that may have needed to be considered in the discussions between the U.S. and NMED. And I'm really seriously considering what further progress could be made through some direct conversations, not only between NMED, but also some of the other agencies, as Mr. Atencio had mentioned. I'll also be interested in knowing what our hearing officer feels about that type of a process, or that piece being added to your proposed process.
Thank you, Vice Chair Cipher. So I do believe there were extensive opportunities for settlement discussion. So I don't know that additional discussion will be fruitful, but I also defer to the hearing officer to weigh in on that.
Thank you.
The evidentiary record, Vice Chair Cipher, is closed, and this oral argument proceeds on those confines. And so unless the commission decides to remand this back to the Groundwater Quality Bureau for further development, I believe that my role would be to gather the evidence that I found to be persuasive to issue my report and for the commission to come to a decision based on the rule 20.1.3.16 subsection F subsection 3, which discusses the decision-making process. So that's my input.
Thank you. Commissioner
Thank you.
Dominguez, did you also have comments?
Yes, thank you, Madam Chair. I would concur with you as far as the process moving forward. I believe at the July, well, WQCC meeting when we were kind of running through the logistics on this, it specifically laid out somewhat of a timeline of notice of transcripts, and then parties would have 30 days to prepare findings of fact, conclusions of law, and then the hearing officer would have 2 weeks to prepare a report. So I think that had sort of previously been laid out and was actually captured in our minutes from our last meeting. To the point of I guess that's still a little bit lingering of whether a hearing officer's report and a recommendation, or if it's just a hearing officer's report, is probably a decision before the commission. To get the ball rolling, I guess I would probably lay out there that I think the commission has always found valuable the hearing officer's report, and place a decision burden on the commission itself. But I'll just throw that out there for discussion purposes for fellow commissioners. Thank you, Madam Chair.
Thank you, Commissioner Dominguez. The order dated March 16th states that the commission designates Gregory Chakalian as the hearing officer to review the record and arguments of the parties and to recommend a decision to the commission. So I believe we have the authority to amend that, but I just wanted to reference the original order that did request an actual recommendation from the hearing officer. Is there any discussion from other commissioners on amending the original order? This is when I wish Council Sanchez or replacement was here to make sure we're following the legal guidelines correctly. But I do believe it's within our authority to amend that order to request just a hearing officer report. Commissioner Dominguez.
Madam Chair, I guess maybe to help us along with the process, I guess I would throw out a question to the hearing officer if he was already sort of headed down a particular path, one direction or the other, and provide us a little insight from how he was already looking at approaching this. That may be an unfair question, but I'm past the point of being fair. Sorry for that, Mr. Hearing Officer.
Thank you, Commissioner Dominguez. I don't have a path laid in stone at this point. I serve at the pleasure of the commission. If you feel as though a recommended decision would not be helpful in this case, I am happy to omit that from my hearing officer report. If you are looking for a report within 2 weeks, it would also, I think, be helpful not to have to deal with that part of the report. I hope that was helpful.
Mr. Dominguez, did you have any follow-up on that? Okay. Okay, so given that, oh, Commissioner Brancard, did you want to say something?
I guess just to, since Mr. Dominguez didn't give us a definitive answer, I say we go with the initial report, the initial delegation, and give Mr. Hearing Examiner 30 days after the transcripts are submitted. Uh-oh, I see a nodding no.
Commissioner Brankard, the way I laid it out in my discussion at the last meeting was that after the notice of transcript is filed, the parties would have 30 days to produce their recommended findings and conclusions of law, and then I would have another period of time to compile that into a report that would then either be, depending on how the commission feels about this, either be circulated back to the parties for a period of comment, and then I would have another short period of time to compile those comments into my final report. That would then begin the deliberation process. Now, there is nothing in the rule that seems to bind the commission, by my reading of it, to a particular 60 or 90 days. I've searched through this rule for a timeline for a decision, but I don't see it here. So that being said, it would take more than 30 days after the filing of the transcript for me to produce a final report. Thank you.
I believe we have 60 days from within the hearing out from when the hearing officer report is provided to make a decision. I don't have the exact citation here, but I know I looked this up yesterday.
Chair Stringer, there is a 90-day period of time under subsection B1, but that was waived. The petitioners filed a motion and the order was issued granting a waiver of the 90-day timeline.
Okay, so under 20.1.6.306, the commission shall reach its decision on the proposed regulatory change within, oh, this is for
That's a
regulations,
different.
not permit. Okay, I'm mixing the two.
We're operating under 21.3, Chair Stringer, and I've searched carefully. Maybe Council Atencio or Captain Davis has a citation they want to bring into this discussion about the timeline for a final decision.
Mr. Hearing Officer, Chair Stringer, I'm unaware of a specific timeline as contemplated in 20.1.3.
Captain Davis?
I concur with that. The only timeline I was aware of was the 90-day, which we waived, so.
Okay, thank you. No, I acknowledge I was mixing the permits and the regulation timeframes in my head, so sorry for the confusion on that. So given that, we certainly want to resolve this matter as timely as possible. So I would recommend that we proceed as proposed with getting the hearing officer's report that includes a recommendation as originally ordered last March, and plan for, I would say, no comments on the hearing officer report once issued, so that we would have the ability to deliberate this at our October meeting, given the time frame of getting the transcript and the findings of fact.
Chair Stringer, do we have, excuse me, do we have the court reporter available? Can you give an estimate of when this transcript will be available?
I think she's looking for her mute button there.
I'm looking for the unmute button, yes. Within a week to 10 days at the most.
Okay.
Do you need
Right.
it sooner than that?
the Air Force is paying for this transcript, I'll let them answer that question. Captain Davis,
That's fine with us, sir.
you're fine with that? Okay. Court reporter, can we say a week for a couple hours of the transcript?
Yes, I will try to get that done. I do have jobs every day this week. So yes, I will get it done within a week.
Okay, thank you very much. And then Chair Stringer, the way I had envisioned it is if we get the transcript by let's just say the 16th or the middle of August, the parties would have until the middle of September to submit their post-hearing briefings. And then if the commission wants to deliberate by October, that seems to be plenty of time. And Chair Stringer, I think it would be, I could shorten my time period down, but I think it would be very helpful to me, both for accuracy and fairness perspective, to get comments on the preliminary report and recommended decision. I find the comments to be very helpful, in fact, and generally, get good information from that. So I could easily deliver a final report to the commission before by the 1st of October, and I'll just condense my time to allow for that comment period and then my final revision, if that works for the chair and the commission.
So I have no objections to that. I'll certainly seek for any other commissioners to weigh in. Commissioner Dominguez.
Yes, thank you, Madam Chair. Just so that I'm clear, because we've kind of gone full circle here. So your recommendation was staying with the original order, and we will have the hearing officer generate a report and a recommendation, correct?
Correct. That was based on Commissioner Brancard's proposal as well.
Okay, and for a recommendation, the hearing officer is good with the goal of October. Okay, just wanted to make sure on that.
Okay.
Thank you, Madam Chair.
Thank you. So I don't think any of this requires a motion or a vote because we're proceeding with the original order as planned, and we have the established timeline to resolve this matter for deliberations in October. Any other closing concerns or comments before we move to the next agenda item?
I'll just make one last comment that I will issue a scheduling order by tomorrow to the parties so that they know what the deadlines are for their post-hearing submissions and their comments, and then my final report.
Thank you, Mr. Pukalian. Okay, that concludes agenda item number 6. Okay, now moving on to the slightly more complex agenda item, which is WQCC 22-21. There are 2 components of this. First, a petition for review of the New Mexico Environment Department's groundwater discharge permit DP 1132, as well as Triad National Security's motion to stay proceedings pending the resolution of related adjudication. And so with that, I will turn the floor over to Lindsay Lovejoy, I believe. We'll pause for Okay, we can hear you now.
Okay, good. And I was not sure how my name would appear here. My computer connection was cut off somehow, so I'm now speaking through Joni Aaron's computer, and I hope it works. The matter before us, I take it, has been set for consideration because my parties that I abbreviate as the citizens, CCNS and Honor Our Pueblo Existence, have asked for a remand of the case to the Environment Department so that some decisions can be made. And under the rules, that needs to be addressed kind of upfront. I'll try to go quickly through the legal arguments. I don't have slides or that kind of thing. We filed an opening brief. Not sure what the date is. July 18th. And if members want more detail on the legal issues, I'd recommend they go there. There are two major issues in this case that have been present in the case from the beginning that require a decision by the Secretary of the Environment Department, but have not been decided. We submit that the case should be remanded to obtain the Secretary's decisions. The Commission sits as a court of appeals, not a court of original jurisdiction, and the Secretary should be making these decisions initially, not you. The first question is whether the Water Quality Act, under which DP 1132 was issued, even applies to the waste management activities at the Los Alamos Radioactive Liquid Waste Treatment Facility. The Secretary, in a non-final order, June 23rd, 2020, says that the citizens have asserted that the Hazardous Waste Act is more stringent and for that reason should apply here. This is not correct. The citizens contend that the Hazardous Waste Act is legally required to apply. There's no question here of debating which law is the better law, and it's quite misleading to imply that. It does happen to be true that several Hazardous Waste Act regulations are more prescriptive and more protective than the Water Quality Act, and to deny application of the Hazardous Waste Act withholds legally required protections from New Mexico citizens. For instance, the Hazardous Waste Act requires that a applicant address seismic safety at the site, and there's no such provision under the Water Quality Act. The Hazardous Waste Act applies here because it has been authorized by the EPA to enforce the Federal Resource Conservation and Recovery Act, or RCRA, and as such it has the force of federal law. Under the U.S. Constitution, federal law is supreme, and I'm quoting, "This Constitution and the laws of the United States, which shall be made in pursuance thereof, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding." Under federal law, 42 U.S.C. 6926D, an authorized state program and actions under that program have the force of federal law. The principle of the supremacy clause as it applies here is set forth in section 74-6-12B NMSA 1978, which is part of the Water Quality Act. And we heard discussion of that in connection with the previous case. 74-6-12B is entitled Limitations. And it says, I'm quoting, "The Water Quality Act does not apply to any activity or condition subject to the authority of the Environmental Improvement Board pursuant to the Hazardous Waste Act and certain other statutes, except to abate water pollution or to control the disposal or use of septic and sludge. In this instance, this permitting proceeding has been going on. It started in the mid-90s. It is undisputed that the radioactive liquid waste treatment facility stores and treats materials that are hazardous waste under the Resource Conservation and Recovery Act and under the Hazardous Waste Act. LANL, Los Alamos Labs, has conceded that the facility, quote, will receive and treat or store an influent wastewater, which is hazardous waste as defined in 40 CFR 261.3. This is undisputed. The Hazardous Waste Act in turn requires a facility that manages hazardous waste to obtain a hazardous waste permit. The legislature has directed the Environmental Improvement Board to issue regulations, and I'm quoting again from 74-4-4 NMSA, regulations, quote, requiring each person owning or operating or both an existing facility or planning to construct a new facility for the treatment, storage, or disposal of hazardous waste identified or listed under this subsection to have a permit issued pursuant to requirements established by the board. And under the legislature's direction, the EIB has adopted regulations requiring persons who treat, store, or dispose of hazardous waste to have a permit under the Hazardous Waste Act. Section 20.4.1.900 of the Administrative Code adopts the terms of 40 CFR 270.1b, which states, I quote, 6 months after the initial promulgation of the Part 261 regulations, treatment, storage, or disposal of hazardous waste by any person who has not applied for or received a permit is prohibited. Since the RLWTF, that's the acronym here, treats and stores hazardous waste, it is subject to the authority of the Environmental Improvement Board pursuant to the Hazardous Waste Act. Therefore, the Water Quality Act does not apply to the RLWTF, and there is no legal basis for the Water Quality Act permit DP 1132. There is no way to avoid this issue. The jurisdictional issue has been squarely presented to NMED. It's in our proposed findings of fact and conclusions of law filed in January 2020. It's in our comments on the hearing officer's report filed in February of 2020. Now, what to do in this situation? Section 20.6.2.3109b of the code requires the Environment Secretary, in issuing a final order with a Water Quality Act permit, to address, quote, all significant comments raised during the public comment period or at any hearing, unquote. It says, the Secretary shall, within 30 days after the administrative record is complete and all required information is available, approve with conditions, or disapprove the proposed discharge permit, modification, or renewal based on the administrative record. The Secretary shall issue a response to comments, which shall specify which provisions, if any, in the draft permit were changed, and the reasons for the change, and shall briefly describe and respond to all significant comments on the draft permit raised during the public comment period or at any hearing. The Secretary has not followed this rule. Instead, the Secretary first issued a non-final order on June 23, 2020, calling for further proceedings about financial assurance and directing the hearing officer to submit a revised report after those proceedings were finished. But the hearing officer made no revised report after the financial assurance proceedings. And Importantly, the Secretary made no responses to the comments on the draft permit raised during the public comment period or at any hearing, as required by 20.6.2.3109. We are left not knowing what the Secretary thinks about the application of the Water Quality Act to a facility that unquestionably manages hazardous waste and is subject to the Hazardous Waste Act. We do not know what the Secretary thinks of the hearing officer's decision, which is, I submit, baseless, that DP 1132 is an abatement permit when it clearly is no such thing. The second major issue about which the Secretary is duty-bound to state his position, but has not, involves the requirement in 74-6-5A and MSA 1978 that a Water Quality Act permit be, quote, a permit for the discharge of any water contaminant, unquote, when the record contains no plan or proposal or commitment to discharge. Since 1998, the RLWTF has operated under a zero liquid discharge plan. In November 29, LANL stated in this proceeding that it planned to discharge from the RLWTF only when evaporation equipment is unavailable or if the volume of treated water exceeded its expectations. And this is contained in the exhibits number 4 and 5 introduced by Triad, one of the applicants here in the hearing. The volume of water sent to the RLWTF has been decreasing for years. And at the same time, Los Alamos Labs has added a mechanical evaporation system and built solar evaporation tanks to handle the wastewater volume. By the year 2010, discharges had effectively ceased. At the hearing in November 2019, both Mr. Pullen, witness for NMED, and Mr. Beers, witness for Los Alamos, stated that a discharge from the RLWTF's outfall is, and this is a quote, highly unlikely, unquote. That's how the record stands. Now, in responses to comments filed by the Groundwater Quality Bureau in 2020, the Environment Department, or that bureau, states that NMED is authorized to issue a permit for what they call a potential discharge, something that's not mentioned in the Water Quality Act or any regulations as the basis for permitting, and which NMED does not define. A supposed authority to regulate an undefined potential discharge is not in the Water Quality Act, and if it were, would amount to an unlimited administrative power, which would violate the New Mexico Constitution. The Secretary must be asked to state whether that is the basis for this permit. Now, in this case, Triad has sought to introduce evidence of new discharges occurring in late 2021 and early 2022, apparently to show that LANL plans to discharge from the RLWTF. I am referring to the recent briefing in support of Triad's motion to stay, which makes reference to items in the EPA proceeding before its Environmental Appeals Board. And these data are themselves from sources outside of the record of that case. But as we know, and as someone has already mentioned today, appellate review in this commission is conducted on the record made in the department under 20.1.3.16, the paragraph labeled decision, I think it's F3. The commission shall consider and weigh only the evidence contained in the record before the department and the recommended decision of the hearing officer, if any, and shall not be bound by the factual findings or legal conclusions of the department. but review is limited to the record. Concerning these non-record materials, 3 things should be noted. First, these data could not have been the subject of testimony and cross-examination at the November 2019 hearing to find out, for example, why these discharges were made. At that date, the discharges had not even occurred. Second, there's no suggestion that the Environment Department relied at all upon discharges occurring in 2021 or 2022 in issuing DP 1132. To introduce such information after NMED's decision is announced and an attempt to support its decision amounts to an illicit effort at post hoc, after the fact, rationalization of the agency's decision and is classically improper on appellate review. And third, the usual justifications for a discharge, the unavailability of evaporation equipment or new demands for disposal capacity, do not seem to apply to these discharges. Without any such explanation, one is left with the inference that the discharges were engineered to influence these permitting proceedings. This would mean that they are the sort of contrived explanation for agency action that Chief Justice Roberts in Department of Commerce v. New York in 2019 classed as simply a distraction. On judicial review, his words were, "Accepting contrived reasons would defeat the purpose of the enterprise," unquote. The issuance of DP 1132 must be based on a plan or proposal or commitment to discharge in the future. Los Alamos has not changed its position that in the future it will discharge when evaporation equipment is unavailable or disposal capacity requires it. This position, not occurrences in the recent past, is the basis on which a permit must be issued, or, in this case, denied. Citizens submit the proper course here is to send the permit back to NMED so that the Secretary can address these issues which are squarely presented in this case. Thank you, and I'll respond to any questions.
Thank you. I'd like to also hear from the other parties in this matter. I think next on the list would be John Virgil with the New Mexico Environment Department.
Thank you, Madam Chair. I think Council's presentation of the legal argument here may be somewhat premature. My understanding is we're not arguing the actual permit review at this time. However, to the extent that he has reiterated his client's request that this matter be remanded back to the department, I'll try to go through a few things and hopefully shed some light on this and correct some misstatements. The first thing is, there is a pending motion, Madam Chair, as you are aware. In fact, there are 2 pending motions. There's Triad's motion to stay this proceeding pending resolution of the EPA's Environmental Appeals Board matter. And the reason that that's important is one of the main arguments that you just heard Council explain was that this facility, their assertion that this facility must be regulated by the Hazardous Waste Act as opposed to the Water Quality Act, based on the preclusion of the Water Quality Act if the Hazardous Waste Act applies. Well, as it turns out, the EPA Environmental Appeals Board is set to rule on the question of whether or not an NPDES permit, which had previously been issued for this facility and which then was renewed for this facility, was it properly renewed? Has it been properly issued once again in this case? That's important because if a wastewater treatment facility such as this is regulated pursuant to Section 402 of the Federal Clean Water Act, that's the part under which the EPA can issue NPDES permits, then it can qualify for a wastewater treatment unit exemption. And then the question of whether or not the Federal Resource Conservation and Recovery Act, and therefore the State Hazardous Waste Act, applies would be settled by that board, in essence. And that's why Triad, as I'm certain they will explain in a minute, filed their motion for a stay pending resolution of that outcome. In other words, there's not really a reason to argue whether or not this facility can or should be regulated under the Hazardous Waste Act if another tribunal is already engaged in that process and will make that determination for this commission. So,
Mr. Virgil, can I ask you to pause there? I can hear you still, but one of my earbuds died while I just switched so that I make sure I hear everything you're saying. Just give me 1 second, please.
Okay, can you all hear me?
I can.
Okay, and I can hear you. Thank you.
All right.
Sorry for that interruption.
No, that's fine. Thank you. I'll continue. That's my first point. The second point is petitioners assert that this matter should be remanded back to the department for the secretary to make some determinations. This discharge permit has a fairly lengthy history, as one can tell by the fact that the administrative record has over 20,000 pages to date. So first, a public hearing on this discharge permit was held in April of 2018. That matter was eventually, or that hearing, I should say, was eventually vacated based on an issue of an appearance of bias by the hearing officer who conducted the hearing. So there was a second hearing held in November of 2019. After that, all the parties, the hearing officer submitted his report. A new hearing officer, I should add, submitted his report. The parties submitted their proposed findings of fact and conclusions of law. It was proceeding along on the normal trajectory for a discharge permit hearing. However, at that time, on June 24th, 2020, the secretary issued an order remanding the discharge permit back to the Groundwater Quality Bureau for the consideration of financial assurance conditions. Importantly, in that order, the secretary did in fact opine on the applicability of the Hazardous Waste Act and the Federal Resource Conservation and Recovery Act to this matter. He said that the questions of whether or not those laws applied were not properly before the department in a discharge permit proceeding. If they were going to be pursued, they should be pursued via some other option. And there's no need for us to argue that right now because, again, EPA's Environmental Appeals Board will be deciding whether or not the Hazardous Waste Act actually applies to this facility. But I will add that the secretary, in making his June 2020 order, asserted that yes, in fact, the Water Quality Act did apply and this discharge permit could be issued pursuant to the Water Quality Act. However, also in that order, he remanded it back to the Groundwater Quality Bureau for consideration of financial assurance. That order contemplated that once a new permit with potentially financial assurance conditions was public noticed, that there would be requests for a hearing, potentially another public hearing, after which the hearing officer could submit another hearing officer report. In December of 2021, the Groundwater Quality Bureau did in fact public notice a discharge permit. The only differences between that permit and prior versions of the permit were indeed financial assurance conditions, which were referred to as financial responsibility conditions. Those were the only differences other than matters that had already been adjudicated at the November 2019 hearing. So the Groundwater Quality Bureau public notices that permit. I think the comment period was 61 days to allow both the applicants and any interested person to submit comments. The sets of comments that were received, which were from petitioners as well as several other groups, were all very similar to each other. And unfortunately, and this is articulated in the Secretary's hearing determination, which is part of the record, unfortunately, none of them made any substantive comment on the subject, the new subject of this permit, which was financial assurance conditions. They were framed as preliminary comments, and rather than making substantive comments either to the effect of what petitioners have claimed here or about financial assurance, they were all procedural in nature. And they certainly did not properly request a hearing in that they, I think only one of them said anywhere in the text of the comments itself, request for hearing, but they certainly did not specify the reasons why a hearing should be held. And in fact, given the lack of substantive comment on financial assurance requirements and the financial assurance conditions in the permit, one wonders on what topic we could possibly have a public hearing. So this is all to say that the reason that there is no additional hearing officer report and also no additional response to comments from the Secretary is that all of that was truncated when a hearing was not held. A hearing was not held because it was not properly requested. And again, this is all part of the administrative record. It's in the hearing determination memo issued by the Secretary. So that is to say, were the commission to consider remanding it back to the department at this time, I would urge you not to do so, because unless and until there's a proper request for a hearing and there are any substantive comments on financial assurance, the Secretary has made all required determinations in order for this commission to review the legitimacy of issuance of this discharge permit. In other words, this commission may properly act in its appellate capacity, in my opinion, pending the outcome of the EPA's appeal board decision on the wastewater treatment unit exemption. Finally, I will add, Council has asserted that there's no text in the Water Quality Act that talks about a potential discharge, and has argued that the Water Quality Act cannot regulate a potential discharge. There are examples of other discharge permits in the administrative record, which are considered zero discharge facilities. That is, they only discharge in the event that something goes wrong or something fails or there is an emergency. The petitioners have, in this case, submitted their brief in chief, and of course, the answer briefs are not due until this Friday. So we don't have an argument in the record at this point as to that. However, I will say that the argument that the Environment Department can only regulate discharges after pollution has already occurred or is occurring really confounds the whole intent of the Water Quality Act, which is to protect water quality within the state of New Mexico. So to the extent that Council says that this facility must, quote, plan or propose or commit to a discharge, those words are also not contained in the Water Quality Act. So if there's an objection to our regulating a potential discharge that can potentially contaminate groundwater, I would assert that the purpose of the Water Quality Act is to prevent pollution, not to begin regulating it once it has already occurred. And the other point I'll make, and this is my last point, Council has complained of the record of discharges that were submitted by Triad in their recent reply in support of their motion to stay, and has asserted that all of those discharges were after the last public hearing. That is not accurate. In fact, there is a discharge on June 18th, 2019, which certainly is right there on what they submitted. That was prior to the November 14th, 2019 public hearing. in this matter. And that discharge and similar discharges were in fact discussed at the November 14, 2019 public hearing. So I will stop now, and if there's any questions, I'm happy to respond.
Okay. Thank you, Mr. Virgil. We'll now hear from Triad's representative. Is that Mr. Wexler?
Yes, Madam Chair. Good morning, Madam Chair and members of the commission. I'll mention also that Maxine McReynolds, Chris Stoneback, and Christina Mulcahy from the Office of the General Counsel at Triad are also present. And just a matter of clarification, I understand that I should address only the petition now and reserve the argument on the motion to stay for the moment. Is that correct? I'm happy to proceed with that argument if that's your preference.
Yeah, I think just for clarity and keeping it straight, let's just focus on the one action, the petition to review at this moment.
Very well. Thank you, Madam Chair. And in that case, I can keep it very short. I agree with everything that Mr. Virgil just indicated. It's our position that the petition for review should be denied and the permitting action from the department should be affirmed. Mr. Virgil covered some of the background. Triad, as its successor in interest, has been pursuing a discharge permit for the RLWTF for over 25 years now. It's been the subject of 2 separate evidentiary hearings, and in each one, the hearing examiner recommended adoption of DP 1132. And I think that should give the commission some comfort that the permit is protective of groundwater. I also agree with Mr. Virgil that the argument on the merits is premature. It's not time for that argument. In fact, neither the department nor the permittees have filed our answer briefs. So you don't have the benefit of our briefing on the merits. And rather than the substance, the commission needs to determine how to address this matter procedurally, including whether to stay the proceedings. But briefly, to indicate our position again, petitioners raised the 2 what they term major legal issues in their petition. The first is whether a permit should be issued if there's no discharge. And the second is whether the Hazardous Waste Act and not the Water Quality Act should apply. Now, contrary to petitioners' argument, each of the issues has been addressed more than once, and we'll be able to explain that in our answer brief. Moreover, petitioners' position on these issues are based on a misunderstanding of both the evidence and of the law. On the discharge issue, the record's replete with evidence of both past and likely discharges from the RLWTF. Petitioners are aware of this evidence, but they choose to ignore it. And even if that were not the case, as Mr. Virgil just indicated, the language of the Water Quality Act makes clear that the department is authorized to issue discharge permits in exactly the scenario presented here to avoid pollution of groundwater. Now, petitioners' position amounts to arguing that discharges must actually occur and pollution actually occur before a permit can be issued. And to protect the environment, that cannot be the case. On the Hazardous Waste Act issue, that jurisdictional question, this matters properly before the commission under the Water Quality Act, under this discharge permit that's been issued by the secretary. And in any event, the RLWTF is subject to a very well-recognized exemption from the requirements of RCRA and the Hazardous Waste Act. And as Mr. Virgil just indicated, that exact issue is currently pending before the EAB. Now, the secretary made a determination that the petitioner's jurisdictional argument is not a bar to consideration and issuance of DP 1132. Petitioners don't like that decision, but it is the decision that was made. So there's no merit to this idea that there's benefit to sending it back to the secretary for additional determinations. And in all, the commission should confirm that decision and should confirm the issuance of DP 1132. Thank you.
Thank you. And lastly, we'll hear from Mr. DeRoma, counsel for DOE. Is he present?
Madam Chair, I did see Stephen Yoakum on behalf of the Department of Energy, but they are co-movants with us. I don't know if Mr. Yocum has additional comments or not this morning.
Sorry, Stephen Yocum here. We have no additional comments.
Okay, thank you. Okay, so for this particular matter, just the petition for review, the commission is being asked to grant this request or not. So I look to the commissioners to either ask questions of the members or the attendees rather, or discussion. And I see Commissioner Brankard turned his video on.
Madam Chair, I guess I would agree with Triad's counsel that perhaps we need to be looking at the procedural matters here first. We have a motion to stay, we have a motion to toll or something, a delaying motion, I think you call it. And then we have a request for a remand, which, you know, I would certainly want to ask the petitioners a little more clarification on that. But beyond that, we have a schedule for them for briefing, after which we can have additional oral arguments or have a hearing officer's report, however we'd like to do that. But we have a fully filed motion for stay here that we probably need to address sooner rather than later.
Okay, thank you, Commissioner Brankard. Go ahead, Commissioner Dominguez, I'll respond.
Yes, thank you, Madam Chair. This is more of a question on the petition for review. And so looking through the docket, the petition that was filed is labeled as a petition for review. Yet within the latter part of that petition, it morphs more into a petition for remand. So I'm looking at 20.1.3.16A3, and I'll read from it here, remand to the department. A party must request the commission to remand the matter to the department. A request for remand must be filed simultaneously with the permit review petition. So I guess what I'm trying to wrap my head around, and maybe all the parties can provide some insight here, is what was filed. Is it a petition for review, or is it a petition for remand? Because I think what we've seen at times in the past is the terminology that's stated there, filed simultaneously, is that there's two petitions, a petition for review and a petition for remand. So where are we at on this, or did I miss another document that maybe got filed, but I just missed it in the docket?
Mr. Lovejoy, you're muted, sir.
How about now?
We can hear you.
Okay. I want to assure Commissioner Dominguez that he has not missed anything. We combined our petition for review and the request for remand in a single document. Petition for review being essentially necessary in order to assert the commission's jurisdiction to entertain an appeal, and the request for remand being filed as part of that, so that it's no question that it's simultaneously put before the commission. And we think a remand is appropriate because the only expression of the secretary's opinion on any legal matters really is his statement that it's not proper to raise the jurisdictional issue, go ask somebody else. To me, that's, first of all, it was in a non-final order, so that it's not the expression of departmental position called for by 3109. But it just, frankly, is so unusual as to be extraordinary that the secretary should say that the jurisdictional limitation is irrelevant. If he really means that, let's hear him say it and explain it. It's clearly not irrelevant when it's a limitation in the statute on the application of the Water Quality Act.
Thank you, Mr. Lovejoy. So Commissioner Dominguez, does that clarify that they combined their request into one petition? I will say that the threshold for a remand is that there was no reasonable opportunity to submit comment or evidence on an issue being challenged. And Mr. Virgil explained how there was that opportunity. So from my perspective, I think really the issue is it doesn't meet the threshold for a remand. A review is the appropriate action should we choose as a commission to grant that. But again, like to hear from any other commissioners if they have a difference of opinion. Commissioner Brancard.
Madam Chair, I would agree with your analysis. I think that the remand provision in our rules is specifically designed to deal with a gap in the record, a lack of evidence on a particular issue. Mr. Lovejoy stated, quite clearly in his initial argument that there has been considerable evidence presented on the issues that he's discussing. He just doesn't like what the Environment Secretary said or didn't say. I don't think that's really what the remand is about, but I think that in this petition, the petitioners have raised a number of issues that can be reviewed and can be the basis of a review of this permit and could be the basis of us denying this permit.
Thank you, Commissioner Brancard. Commissioner Dominguez, did you have anything you wanted to say here?
I would concur with your analysis and Commissioner Brancard's elaboration on that. I think it's spot on. So I think to keep things moving along, I believe where we're at this point is more of a process question of whether the commission accepts the petition and schedules a hearing, and then we address the two pending motions, or as Commissioner Brancard had alluded to, if those two pending motions are handled prior to taking an action on the petition itself. And if councils from any of the parties have input on that, that would be great. Thank you, Madam Chair.
Thank you, Commissioner Dominguez. Mr. Virgil, did you have a comment?
I did. I'm taking up Commissioner Dominguez on his invitation if council had any suggestion on that. I think I would suggest that this commission bifurcate the decision whether or not to grant the permit review and then schedule a permit review hearing into those two separate parts, whether or not to grant the petition for review, but then not necessarily jump into scheduling it until you've actually heard and made some decision on the motion to stay, since a motion to stay would necessarily then not require that the commission schedule an actual permit review hearing, if that makes sense. In other words, I don't see the point in scheduling a hearing if you're going to then grant the motion to stay and vacate that date.
Yeah. It's kind of a chicken and egg thing here. So that makes most sense to me because we wouldn't be able to address the other issues if we did it combined. So I think we should bifurcate. I think we need to weigh in as a commission on the decision on whether or not we will grant the petition to review, understanding that essentially based on the discussion, it doesn't look like we have support for the remand. And because that's combined into one petition, we'll have to address that, I believe, in one motion. But let's have the discussion on whether or not to grant the petition to review the permit at this time. Any comments from commissioners on whether or not we should review the permit? Commissioner Dominguez, your camera is on. I don't know if you want to say anything though.
To keep things moving forward, I think I agree with what's been you've laid out of separating the items. So given that, I would make a motion that the commission accept the petition for review and end the motion at that until we clean up other items. And then we can deal with anything else down the road.
Okay, thank you.
Second.
Thank you, Commissioner Brancard. We'll take a roll call vote on the motion to accept the petition to review and postpone scheduling pending the outcome of the additional procedural matters.
Thanks, I had to write that down. All right, we'll begin the vote on that well-worded motion. Commissioner Brancard, how do you vote?
Yes.
Commissioner Candelaria?
Yes.
Commissioner Dominguez?
Yes.
Commissioner Fry?
Yes.
Commissioner McWilliams?
Yes.
Vice Chair Cipher?
Yes.
Commissioner Thompson?
Yes.
Commissioner Velasquez?
Yes.
Commissioner Zemlick?
Yes.
Chair Stringer?
Yes.
The motion passes.
Thank you. So moving on to the next procedural matter, we have the motion to stay and the motion to toll. Not sure how to describe that. It's a weird term for basically stopping the timelines is what I understand. Any discussion on the, actually, I'm going to ask a question of the panelists before we get into further discussion. When the outcome of the appeal to the board, if that results in a determination that it is subject to the Hazardous Waste Act, what happens to the permit in that circumstance? Can anyone help me understand that?
Madam Chair, are you asking what happens to the Water Quality Act permit, the discharge permit?
Yes.
So the issue, as Mr. Virgil outlined, is that there's a well-known, well-accepted exemption to the applicability of RCRA. And as you know, one of the two, what they term major issues from the petitioners is that it's the Hazardous Waste Act, the state version of RCRA that should apply. But in order to avoid duplicative and overlapping regulation, RCRA has several exemptions, of which one of them is the wastewater treatment unit exemption. So for any facility that's permitted under the Clean Water Act with an NPDES permit, RCRA simply does not apply. And because the state of New Mexico does not issue NPDES permits, whether an NPDES permit is issued will be determined in that EAB proceeding. Now, if the EAB does issue an NPDES permit, then that may completely address that second major issue raised by the petitioners, and it will simply no longer be relevant because it will have been addressed. Petitioners make some argument in their brief that it would only, a decision by the EAB would only eliminate part of their position. We don't agree with that, but even if it were true, it would still be prudent for the commission to have the benefit of that decision, so you'd know the scope of what you're dealing with.
May I, Madam Chair, may I address this issue?
Yes, please do.
If the Water Quality Act permit is vacated on remand, then the Hazardous Waste Act would apply. Mr. Wexler is making reference to the wastewater treatment unit exemption. That is already addressed in the current Hazardous Waste Act permit for Los Alamos Laboratory. And it states that the wastewater treatment exemption would only apply, as the EPA has itself said several times, if a facility disposes of all the treated water through an NPDES permitted outfall. Now, since the late 90s, the RLWTF has been reconstructed around the concept of zero liquid discharge and channels the major part, if not all of its treated water through evaporation units, the mechanical evaporation system, which is requires, I think, gas power, and the solar evaporation tanks, which are, I think, just coming into use. The fact that treated water is disposed of through means like these, which are not the NPDES permitted outfall, would disqualify the site for the wastewater treatment unit exemption. That's clear.
Okay, thank you. I appreciate that context to proceed with consideration for the motion to stay the proceedings. And I'd like to open it up to the commissioners to discuss this motion. Commissioner Dominguez.
Madam Chair, just to provide opportunity, I think previously the parties focused on the petition for review, and they may want an opportunity to actually focus on the motion for stay, and that's probably a little bit more in Triad's part there, because their part for petition for review was limited. So it might be good to hear from Triad specific to their motion to stay proceedings. Thank you, Madam Chair.
Thank you, Commissioner Dominguez. They did, specify that in their original comments. So I stated they would have that opportunity and would like to give them that. Thank you for the reminder, Commissioner Dominguez. Mr. Wexler, please proceed.
Thank you, Madam Chair. Just to add to the background on the as it's relevant to the motion to stay, after the second evidentiary hearing that Mr. Virgil alluded to, the Secretary accepted the recommendations of the hearing examiner, but remanded to evaluate financial assurance. It's also relevant to understand a little bit about that EAB proceeding. As Mr. Virgil indicated, it's evaluating a NPDES permit renewal. It's fully briefed. We anticipate a decision within a matter of months. That matter involves the same facility, the RLWTF, and many of the same parties, including the petitioners and the respondents. And petitioners there also raised several of the exact same issues in that case that they raise in opposition to the motion to stay and in their petition. So as we outlined in our papers, the commission should stay this proceeding pending the outcome of that EAB proceeding. And I think I can boil it down to two main reasons. First, the matter should be stayed to avoid inconsistent decisions between this commission and the EAB, and to give the commission the benefit of that ruling for the reasons that I mentioned earlier. As I indicated, the EAB proceeding involves the same facility, the same subject matter, water quality, and the same parties, petitioners and respondents. And it also involves those same issues, and both petitioners are raising those two basic arguments, those two, quote, major legal issues, whether a permit can be issued if there's no discharge, and whether the Hazardous Waste Act and not the Water Quality Act should apply. Now, neither of these arguments have any traction because they misstate the facts. The record's clear that there are discharges, and they misunderstand the law. But more importantly for the motion to stay is it's not necessary for you to resolve these two issues for the procedural motion. They represent the merits of petitioners' arguments, and this is purely a procedural motion. So really, the commission need only determine whether it's prudent to allow the EAB to complete its work and to issue a decision addressing those issues. And we think it would be prudent. Staying the matter would allow the EAB to provide the benefit of its decision first, and it will allow the commission to review that decision. As I said, it may eliminate part of the case, part of the argument. At the very least, it'll narrow that scope. And as illustration, the very question that you asked, Madam Chair, about the applicability of the wastewater treatment unit exemption. Now, you heard a little bit from the petitioners, their view that the EAB would only address part of their argument, and I alluded to that. Again, we disagree, but assume that petitioners are correct. Even then, you've narrowed significantly the scope of this proceeding, and then the commission has a better idea of what it needs to address. And that will save everybody costs and expense. Which takes me to my second reason that this matter should be stayed, and that is it will avoid duplicative costs and allow for more efficient proceeding. Petitioners are effectively asking for a further delay and a remand back to the secretary so that they can provide further input for the fourth time in the last 26 years. And I say that because the primary and really the main focus and thrust of their petition is that remand that the commission has just determined will not occur and is unnecessary. The basis for petitioners' argument is the premise that the secretary didn't address the two things they're raising, the two major issues, but that's not correct. Again, just by way of illustration, petitioners suggest that the department did not address whether the Hazardous Waste Act applies, and Mr. Virgil alluded to this, but here's what the hearing examiner had to say about this issue. Quote, NMED's authority to prevent and abate water pollution under the Water Quality Act and WQCC implementing regulations requiring a permit for discharges that may move directly or indirectly into groundwater provide legal authority to require DP 1132. And the Hazardous Waste Act expressly recognizes NMED's authority to, quote, abate water pollution. And the secretary subsequently found that again, this is a quote, the interplay between the Hazardous Waste Act and the Water Quality Act is not a relevant consideration in this matter, as the construction of the wastewater treatment unit exemption is a construct of the implementation regulations of RCRA and the Hazardous Waste Act with relevance to Clean Water Act discharge permits, not Water Quality Act groundwater permits. Now, I want to pause here and interpret that. I think what the secretary is saying there, that the wastewater treatment unit exemption applies to surface water NPDES permits, not to wastewater, not to discharge permits under the Water Quality Act. And my understanding of what the secretary is saying there is this matter, the discharge permit and the Water Quality Act are properly before both the department and the commission. And there's no reason to be accepting that argument of the petitioners. And in fact, the record shows that the petitioners have raised this very issue in the proper forum in the past, both with the department and in the before the Environmental Improvement board. Now, again, I understand the petitioners don't like the secretary's determination, but it's not necessary to grant their relief and remand this matter for further proceedings. Really, the prudent thing is to be staying this matter pending the outcome of the EAB proceeding, which again, we anticipate to be a matter of months. And in closing, I'll offer two final points. The first is that if this matter is not stayed, then our answer brief is due Friday, as is the department's. And so we would appreciate a decision on this matter as soon as possible, hopefully today. And that brings me to the department's motion to toll, which is, it is an unusual word. Essentially, all we're asking is that we be given, we think it's fair to be given the same amount of time to respond to the petition as we otherwise would, and that we ought to be put in that position as a matter of fairness. So we think that if you deny our motion to stay, we obviously think it should be granted. But if you disagree, you should grant the department's motion to toll and allow for additional time to complete the answer briefs, both as a matter of fairness and to put you in the best possible position on which to render a decision. Thank you.
If I may, Madam Chair.
Yes.
There were a few statements in Mr. Wexler's presentation that I'm pretty sure were wrong. The hearing officer, it's true, made some statements about the broad powers available to the department that I consider clearly erroneous. The secretary did not accept the hearing officer's findings and conclusions. He asked for a revised report at the end of the additional proceedings he directed, and we never got that, and the secretary never had to address these issues. And if that's not grounds for a remand, it's certainly grounds for reversal. The other statement that I strongly disagree with is that the EAB in Washington is undertaking entirely similar issues. The EAB may or may not address the applicability of the wastewater treatment unit exemption. I'd be rather surprised if they did, but Atlanta wants them to. But that would normally be part of the permitting, the Hazardous Waste Act permitting process. The other issue that EAB is dealing with has to do with the application of the Clean Water Act when there is only a possibility of a discharge. And although that's a similar rule, a similar issue to what's presented under the Water Quality Act in this case, it's not necessarily the same result. They're separate statutes, and the state may consider that its permitting power extends to certain activities that don't come under the NPDES. All we're going to get if there's a stay is delay. If the commission chooses not to remand, I say the commission should address the issues as they're presented, and the EAB will get to it when they get to it, and they may say something similar and may not. They're working under a different law. Thank you.
Okay, thank you. So in front of the commission is the request for a motion to stay the proceedings based on what was just explained, that there might be this other outcome that would be important contextual information in our proceedings for the permit review. So to me, I think it would be important to know the determination that is made by the EAB. But I seek input from other commissioners or a motion on whether or not to stay the proceedings. Vice Chair Cipher?
Madam Chair, I would offer a motion to stay the proceedings pending resolution of the related adjudication.
Thank you, Vice Chair Cipher. Do I have a second?
Second, this is Commissioner Dominguez.
Thank you, Commissioner Dominguez. Pam, shall we have a roll call vote, please?
Yes, ma'am. Commissioner Brankard, how do you vote?
No.
Commissioner Candelaria?
Yes.
Commissioner Dominguez?
Yes.
Commissioner Fry?
Yes. Sorry, I was not muted.
Thank you. Commissioner McWilliams?
Yes.
Vice Chair Cipher?
Yes.
Commissioner Thompson?
No.
Commissioner Velasquez?
I'm going to recuse myself from this vote, please.
Commissioner Zemlick?
Yes.
And Chair Stringer?
Yes.
So, Madam Chair, you have 2 no votes, a recusal, and 1, 2, 3, 4, 5, 7 in favor. The motion passes.
Thank you. And so that essentially negates the need to make a determination on the request to toll. I'm assuming this is where Council Sanchez would be very helpful, but if it stayed, then there's no need to toll the deadlines, correct?
Madam Chair,
Since I filed that motion, I would concur with that assessment.
Okay. Okay, well, that one was tricky because of the numerous kind of concurrent activities, but we have our path forward. So thank you all for your patience in getting us through that one, and we will proceed at a later date on that one. Moving on to, actually it is 12:17. I want to be mindful of people. We have not had a break yet. I think our last few agenda items are relatively quick, but I want to see if the commissioners would like a 15-minute break or a lunch break so that you can get something to eat. I don't want to work you guys too hard.
Madam Chair, since everybody else is bashful, considering where we are in the agenda, I think if we take a quick break and then just push through the other items, we probably could get stuff wrapped up. So a short break would be fine with me, but I'm open to other commissioners' perspective.
Okay, any other commissioners want to weigh in? I'll say let's take a 10-minute break so that we can wrap it up sooner and people can then go get a bite to eat. And hearing and seeing no objections, we will reconvene. It is 12:18 now, so let's make it a nice even number. We will reconvene at 12:30. Okay, I've got that it is 12:30, so we shall come back into session. And we will go on to agenda item number 8, which is WQCC 22-31 El Paso Water Appeal Petition for Groundwater Quality Bureau. And it looks like Mr. Hanasco?
Yes, Madam Chair. Good afternoon.
Okay, good afternoon. Please proceed.
Madam Chair, we're here apparently on a scheduling conference, so we didn't have notice of this, so we're not entirely sure what is before the commission. We understand there would be an appointment of a a hearing officer considered. So we have filed in both 2231 and 2232 a request for a hearing in this matter. And I might add, to back up, Your Honor, I have Julie Sakura, my co-counsel, with me, and Gunnar Sequist as well from Austin, who is my co-counsel as well. And so we've been in discussions with Mr. Knight of the Environment Department. We have not discussed a waiver of the 90-day hearing requirement, but we are certainly in favor of that because we do anticipate jurisdictional motions being filed in this proceeding to give the hearing officer an opportunity to consider those if appropriate. So with that, I would turn it over to the Madam Chair and the commissioners for any further information you would desire.
Okay, thank you, Mr. Nasco. Mr. Knight, did you have anything to add to this?
Madam Chair, good afternoon, members of the commission. The department would not oppose a waiver of the 90-day requirements either. We agree that the jurisdictional motions and briefing on those could take some time. So, and we would certainly like those issues to be resolved early in the process before both parties spend a lot of time on hearing preparation. So given that, we would leave it to the commission's discretion on the appointment of a hearing officer and scheduling of the hearing. And for that matter, you know, it would be fine with us if the commission would like to simply appoint a hearing officer at this time and allow the hearing officer to work with the parties on scheduling a hearing date. I think that would probably be the most efficient.
I agree. Thank you, Mr. Knight. So I will open the floor for discussion from commissioners on the request for a hearing on the groundwater appeal. Or a motion to designate a hearing officer and allow them to set the scheduling. Commissioner Dominguez?
Yes, thank you, Madam Hearing Officer. First, question for you that might help with framing a motion. I know we have the commission has seems like a pretty full plate of current things and upcoming things. And I don't know where you are at as far as overloading a single hearing officer. If you need the flexibility on assigning a hearing officer, we can make a motion that's fairly generic that leaves that to your discretion and move forward in a manner such as that, if that helps keep things moving forward.
Thank you, Commissioner Dominguez. I think that would be the best option so that we don't have to take the time to consult with the hearing officer for the department to see if he's available. So if we can frame the motion so that it's flexible, so that we can designate the hearing officer at a later date.
Thank you, Madam Chair. And given that, I'll throw out the start of the motion and see if we need to tweak it along the way. So I would make a motion regarding WQCC 22-31 El Paso Water Appeal Petition for Groundwater Quality Bureau, that the commission accept that item and that we allow the chair the discretion of the assigning the specific hearing officer, and that we also accept the parties' input for the 90-day waiver.
I think you did a good job of capturing everything. Any second or modifications to the motion?
Madam Chair, this is Commissioner Thompson. For the sake of discussion, I would second the motion, but I would like to have a little bit further discussion before we vote.
Okay. So we have a second on the table with a request for further discussion.
And so my issue, again, this is Commissioner Thompson, is I've read the petition that was submitted. This looks to me like it's more of a legal issue rather than a water quality issue. And I'm a little bit curious why it's coming to the Water Quality Control Commission instead of going through the courts.
So may I ask counsel to provide a response to Commissioner Thompson's question?
Madam Chair, if I may.
Please, Mr. Knight.
These are administrative compliance orders, and under the Water Quality Act, the department is under an obligation to exhaust our administrative remedies before resorting to a court action. And so in the first instance, we start with an administrative enforcement action, and depending on the outcome of that, we proceed. We may or may not see the need to proceed to court action.
Madam Chair, may I weigh in on that?
Yes, please, Mr. Anasco.
Thank you. I appreciate it. Madam Chair, Commissioners, just to footnote to Commissioner Thompson's statement about court action, in the interest of full disclosure, I think the Commission should be aware that there will likely be a court action simultaneously with this proceeding because of the jurisdictional and preemption and primacy issues that we believe are prevalent under the Clean Water Act and within the jurisdiction of the EPA and the United States Army Corps of Engineers. So that will likely happen simultaneously. The reason we're here is because as counsel stated, that the filing was made, so we had no choice but to answer and request a hearing. So we intend to go through this process and respect this process as well. But we do think there will be some correlative issues in both the court proceeding and in this proceeding. And that's why the 90-day requirement waiver is crucially important to give adequate time for Mr. Knight and myself to consider these issues. And as a further matter, I'd just like to reiterate what Mr. Knight said, that I think it is be more expedient if we confer and deal with the hearing officer on that particular hearing and take that burden away from the Commission.
Thank you, Mr. Anasco. Commissioner Thompson, did you have further discussion?
I do not. Thank you. I appreciate the explanation and the honesty with respect to future legal proceedings.
Thank you. So we have a motion on the table to accept the request for a hearing and the parties' waiver of the 90-day deadlines and the flexibility for the chair to assign the hearing officer. And we have a second. Shall we have a roll call vote, Pam?
Yes, ma'am. Commissioner Brankert, how do you vote?
Yes.
Commissioner Candelaria?
Yes.
Commissioner Dominguez? Commissioner Dominguez, did I miss your vote? Did we lose you? I'll circle back. Oh, I figured you made the motion, but just for the record.
Sorry.
Commissioner Fry?
Yes.
Thank you. Commissioner McWilliams?
Yes.
Vice Chair Cipher?
Yes.
Commissioner Thompson? Commissioner Velasquez,
Yes.
Commissioner Zemlick,
Yes.
Chair Stringer,
Yes.
motion passes.
Thank you. Next up, we have a very similar request, but for the Surface Water Quality Bureau, and I will ask Mr. Anasco if you had anything to add for this particular agenda item.
Thank you, Madam Chair. Commissioners, nothing to add except to suggest that we replicate the procedures for 22-32 that we've put in place for 22-31 in accordance with Commissioner Dominguez's motion. And I think that is, without discussing that again, they have substantial similarities and will proceed along the same binary path that I've mentioned previously.
Thank you. Mr. Knight, do you have anything to add on this one?
Yes, thank you, Madam Chair. I suggest that these two matters, while they are separate compliance orders and they have separate numbers, the department suggests that for the sake of efficiency, that they should be consolidated for purposes of a hearing. They involve the same site, the same discharge, the same evidence, the same parties. So I see no reason why these could not be consolidated into one single hearing.
And Madam Chair, we agree with that proposal by Mr. Knight. I think it's a prudent proposal.
Okay, thank you. This is again when I would have consulted Council Sanchez to make sure this was correct, but it seems very reasonable to me. So right now, commissioners open for discussion on the sort of idea to combine the two procedures and follow the same steps that we outlined in the previous agenda item. Commissioner Dominguez?
Yes, Madam Chair, thank you. In an effort to keep things moving along, I think there is some merit to that. I'm not positive that the commission actually has to make a final determination on that at this point in time. I think within the way that we structured the previous motion, there's time that you could confer with counsel and coordinate with the hearing officer as far as scheduling the hearings or hearing as the scheduling orders get put together. But that's just my 2 cents. Other commissioners may have a different perspective.
Thank you, Commissioner Dominguez. That makes me feel a little more comfortable that I would have the opportunity to consult with counsel for the combining of the hearings, given how it's presented on our agenda. So I like your proposal. I'm not seeing any other commissioners lining up to weigh in on that. So I think we'll seek a motion to approve the request for a hearing, allowing the, oh, Commissioner Dominguez, go ahead.
Yes, I would go ahead and propose a motion unless there's anything else. Given that, regarding item 9, I would move that the commission accept the petition related to WQCC 22-32 El Paso Water Appeal Petition for Surface Water Quality Bureau, and that we again waive the 90-day timelines, and that we provide the chair the flexibility to assign whatever hearing officer fits the scheduling matters.
Thank you, Commissioner Dominguez. I will second that motion and request a roll call vote.
Commissioner Brankard, how do you vote?
Yes.
Commissioner Candelaria?
Yes.
Commissioner Dominguez?
Yes.
Commissioner Fry?
Yes.
Commissioner McWilliams?
Yes.
Vice Chair Cipher?
Yes.
Commissioner Thompson?
Yes.
Commissioner Velasquez?
Yes.
Commissioner Zemlick?
Yes.
Chair Stringer?
Yes.
The motion passes.
Thank you.
Madam Chair, before we leave these two items, and this probably goes without saying, but probably the first time that El Paso has been before this commission. So I just want to, as far as the working with the hearing officer on scheduling a date for the hearing, that we keep in mind that the commission typically lumps these types of hearings in with a regular monthly meeting of the commission, as opposed to being separate dates specific for the hearing.
Thank you for that clarification. So noted for El Paso Water. Okay, thank you. Moving on to the next agenda item, we've got the Environment Department Surface Water Quality Bureau's petition for approval of the total maximum daily load for the Upper Rio Grande watershed and request for hearing. Ms. Weatherly.
Thank you. Good afternoon, Madam Chair and members of the Commission. My name is Crystal Weatherly, and I'm Assistant General Counsel at the Environment Department, and I'm here today representing the Department's Surface Water Quality Bureau, as Chair Stringer just mentioned. With me from the Bureau are Heidi Henderson, who is the TMDL and Assessment Team Supervisor and Acting Program Manager for Monitoring, Assessment, and Standards, and also Rachel Jankowitz, who is a TMDL writer. I want to thank you all for hanging in there today to hear our petition. We filed a petition with the Office of Public Facilitation on July 18th, and we're here today to request a hearing on the final total maximum daily load, or TMDL, for the Upper Rio Grande watershed. Section 303D of the Federal Clean Water Act requires states to develop TMDL management plans for water bodies that are determined to be water quality limited. The Commission is the state water pollution control agency for the Federal Clean Water Act, and the plan that the Surface Water Quality Bureau has developed and is presenting requires approval from the Commission in order to be adopted into the state's Water Quality Management Plan, which is another planning tool which the Surface Water Quality Bureau develops and the Commission subsequently approves and adopts pursuant to the Clean Water Act. Should the Commission adopt this TMDL, it'll be incorporated into the Water Quality Management Plan for the state and also be submitted to EPA for final approval. We won't get into the substance of the TMDL here today, but we're requesting a hearing before the Commission where you'll be able to consider the final TMDL document itself and the presentation provided by the Bureau. The Bureau will submit to the Commission 2 documents ahead of the hearing in a time period at the Commission's preference. The first is the final TMDL. We submitted the draft when we filed the petition. We'll submit the final TMDL, including a new Appendix D that will have responses to public comment. And we'll also submit a PowerPoint presentation ahead of the hearing. Historically, these TMDL hearings have taken roughly 45 minutes to an hour and a half, including the Bureau's presentation and then any questioning by the commissioners or any public comment. And so with that, we respectfully request a hearing on the Upper Rio Grande Watershed TMDL for either the October meeting date or some subsequent date after that. And that is all I have. Thank you.
Thank you, Ms. Weatherly. I will open it up for discussion from the commissioners or a motion. So I will make a motion to approve the request for a hearing, and there's no need to assign a hearing officer. So we can skip that part of it, but I'll make a motion to approve the request for hearing.
Second.
Thank you. Pam, shall we have a roll call vote, please?
Yes, was it Commissioner Dominguez that seconded the motion?
Yes, ma'am.
Okay, thank you. Commissioner Brankard, how do you vote?
Yes.
Commissioner Candelaria?
Yes.
Commissioner Dominguez?
Yes.
Commissioner Fry?
Yes.
Commissioner McWilliams?
Yes.
Vice Chair Cipher?
Yes.
Commissioner Thompson?
Yes.
Commissioner Velasquez?
Yes.
Commissioner Zemlick?
Yes.
Chair Stringer?
Yes.
The motion passes.
Thank you. We will see you soon, Ms. Weatherly.
Chair Stringer, if I may ask one question, the Bureau would like to confirm how far ahead or when we will have this hearing, and then how far ahead of the hearing you would like both the PowerPoint presentation and the final TMDL document.
Thank you, Ms. Weatherly. So based on previous discussion, I had put the hearing slated for our October meeting, sorry. And typically we get the materials, Pam provides them. Well, I'll let Pam speak to that.
Thank you. I ordinarily get the packet of material to the commission. Oh, I don't know, maybe the Thursday before the meeting is my goal. If you've got extensive material for them to review, Ms. Weatherly, I'm certainly happy to send it to them prior to sending the rest of their packet.
Thank you, Pam. We will, I've confirmed with the Bureau that once they have provided a response to comments and have updated the appendix of the final TMDL, it'll be ready to submit a number of weeks ahead of the hearing. It's a hefty document, so.
Okay, thank you. Commissioner Brankard, did you have anything to add to this agenda item discussion?
Well, I guess I was wondering if there's any public notice involved in this hearing?
No, Commissioner Brankard, there was a public notice issued in June 13th, I believe, along with the draft TMDL and a 30-day public comment period, which ended July 13th.
Okay, because I mean, we do have a Court of Appeals decision that says the commission adoption of a TMDL is a rulemaking.
I am not aware of that, Commissioner Brankard. I know that the hearing will be posted on the department's website. I'm not aware of a published hearing notice.
Well, you should take a look at Rio Hondo Land and Cattle versus Water Quality Control Commission.
Thank you, Commissioner.
And I do believe that's why we slated it for October, was to allow the timelines for the hearing notices to be met. So either way, if it is required, you will have sufficient time given the timeline that we established here.
Thank you, Madam Chair.
And thank you, Commissioner Brengard, for bringing that to our attention. Okay, with that, we're on the home stretch now. Agenda item number 11 is our next meeting and expected upcoming matters. So I believe there was someone who wanted to, Justin Ball. Mr. Ball, please proceed.
Madam Chair and Commissioners, good afternoon and thank you for your time. House Bill 546, which includes the Produced Water Act, went into effect July 1st, 2019. Produced water is defined in the Produced Water Act as a fluid that is an incidental byproduct from drilling for or the production of oil and gas. Most produced water is naturally occurring, highly saline water that is recovered during oil and gas production. Produced water may include fluids that were used during drilling, such as hydraulic fracturing fluids. House Bill 546 amended the New Mexico Oil and Gas Act and the New Mexico Water Quality Act. Per the act, the New Mexico Environment Department will regulate
Mr. Ball, you're cutting out, at least for me. I'm not able to hear you anymore.
How about now?
I can hear you now. I could.
Amended the New Mexico Oil and Gas Act and the New Mexico Water Quality Act. Per the act, the New Mexico Environment Department will regulate any use of treated produced water outside of the oil and gas industry in a manner that is protective of human health and the environment. The Oil Conservation Division, OCD, within the Energy, Minerals, Natural Resources Department, or MNERD, will continue to regulate all uses within the oil and gas industry. NMED has identified 2 phases for produced water regulations. Per Water Quality Act 74-6-4.K, NMED is establishing a Produced Water Advisory Committee to advise NMED on the Phase 1 regulation to be proposed for adoption by the WQCC. Developing a proposed rulemaking schedule for review and approval by the WQCC. NMED intends to present the Phase 1 rulemaking schedule at an upcoming WQCC meeting. The Phase 1 rule is a narrow rulemaking to prohibit the discharge of produced water outside of the oil and gas industry at this time. Given the narrow scope and urgent need for the Phase 1 rulemaking, NMED intends to include in the proposed schedule a request that the WQCC deliberate and make a decision without a post-hearing briefing or hearing officer's report, similar to recent WQCC proceedings. Additional justification for this approach will be presented at the upcoming WQCC meeting. Thank you.
Thank you, Mr. Ball. Does anyone else have any other potential matters they want to identify for an upcoming meeting? Mr. Brancard? Commissioner Brancard?
I'm just wondering what the status of the rules that we approved at the last meeting are in terms of filing. Is there anything the commission needs to do?
Are you referencing the ONRWs?
Yes.
Yes, those were provided to me. The ball is in my court for that, and it came in right before I left on vacation. So that's part of my catching up to do.
Do we need to approve the statement of reasons, or can you just do that and get it filed, or how? I'm not sure what the direction of the commission is.
I believe I just signed the final order that approves them. I don't believe there's any further action from any of the commissioners.
Great.
That's how it worked on the previous TMDL, so, or not TMDL, ONRW.
Okay, thank you. Just want to make sure weren't not doing what we had to do here.
Okay. No, this delay was timing with me being out of the office, so I apologize for that delay. Commissioner Dominguez?
Yes, thank you, Madam Chair. And this is more my just standard question looking ahead. For September, what else looks like there is on the docket, I guess, other than what Mr. Ball just talked about?
So I tried to track those. I don't have anything identified for September. I had the Rio Grande TMDL hearing slated as a note for the October meeting, but nothing is on my radar, but I will ask Pam. Are you aware of any matters for the September meeting?
I don't have anything for September, Madam Chair.
Okay, so if we can ask Mr. Ball, if there are no other items, what would the consequences be to postponing your presentation to October?
There's an urgent need to get the process started. I believe we would be able to do it in September, but we will react based upon the needs of the commission.
No, I just wanted to gauge kind of what the timeline was. I kind of expected that answer, so thank you very much. Okay, any other upcoming matter questions or comments? With that, it's a little bit longer than we expected, but thank you all for your patience in getting through quite a long list today, a long agenda for today. And I will adjourn the meeting and look forward to seeing you all next month. Thank you very much.